anticipatory lawsuit has adjourned the matter but not listed. Kindly.
And this matter of 2016 matters. Select some of CAS Act. Another matter.
No, only one. Only one memo. I'll accept only one memo per council, please. Generally feel conscious.
One memo I'm giving my lord. Another matter. I'm not giving my lord.
Go to memo, Nabi.
I might send that is just to submit.
I will go through.
My lord.
Yes. I'll go through the name of the council differs then only. Yes.
Notice has been issued, my lord.
See, come गोटे मेमो देबे
गोटे मेमो देले एटा अन्य अलग काउंसिल में देथे खाली सबमिट कर दा
नहीं सेमता हो नहीं सेमता हो चार जन मना कर कोर्ट मना कर
but in this case notice has been issued, my lord. Specific date was given but it has not been listed.
My lord specific date ओटा जोड़ा रही छी सेटा काई कैश मुक्ति देखियो
my lord it is probable tie up matter.
My lord, this is a covered matter. GRS employee suspended due to arrest. Criminal case, in the criminal case, he is acquitted.
There is no such thing as covered matter in this one. I will go through the file, I will see.
My lord,
I will go through and will see.
my lord, I have quoted the order by which the matter is covered.
How can it be covered? The facts may be different.
Say GRS
Maybe
arrest people suspended.
we'll have to go through the facts. There is no such thing as covered matter. Yes. Yes.
Sir, 75% visually handicapped person.
75?
75% visually handicapped.
Yes.
Come under physically handicapped category. The petitioner in person. WPC number 360 960 of 2021. Sir, what interdate base?
2021 को मैटर टा कौन
Sir, matter is related to appointment of Sikha Sahib.
शिकायत सर खाली हमको 21 में से रही दियो मेमो दियो
Item number 24 in the list. I have filed an application memo with affidavit to withdraw this writ application. May be allowed.
permitted to withdraw.
Obliged.
Supplementary list item number 1, fresh admission.
May I please your lordship. Deserted wife is the petitioner before my lord. Deserted since 2019. Not getting a single rupee from the husband. 3 proceedings are going on in Bhubaneswar. Now he has filed a divorce proceeding in Bhadra. Therefore, I am praying for transfer of the.
All right, take notice. Issue notice to the opposite party by speed post. Requisites for which shall be filed by Monday. A short returnable date be fixed. Place this matter on 3rd May.
Pray for stay.
Further proceedings in CP number 377 of 2023. Pending in the Court of Learned Judge, Family Court, Bhadra, shall remain stayed till the next date.
Item number 2.
Deserted wife wife is residing at Rayagad and opposite partner residing at Malot Jajpur Malot. And only problem Malot that is petitioner Malot. The petition was the only one son, and he is an autism spectrum disorder patient Malot. And the doctor advising to go to your hometown. That is the NIMAS report, Malot. That is Bangalore, Malot. Bangalore.
No, you want it to be transferred from which place to which place?
From Jajpur to Rayagada.
Jajpur to Rayagada. You are residing at Rayagada.
I am residing at Rayagada.
The proceeding has been filed by the husband. It's a Section 9 application.
Section 9 application. Let the matter be. I want Malot to settle the matter. Let it come to Rayagada Malot to settle the matter.
Why?
Because I am residing at Rayagada. I have a son Malot only autism spectrum.
That's true. That is true. I get your point. But the question is, if you are willing to settle, why you are at Rayagada? Can there be a place of settlement?
No.
It has to be. Settlement has to be between two minds. Because it can take place anywhere.
It is very difficult to Rayagada to Jajpur Malot.
All right. Take notice. Take notice to the opposite party by speed post, fixing a short returnable date. The requisites be filed by Monday. Place this matter on 3rd May. Further proceedings in CP number 336 of 2023, pending in the Court of Learned Judge, Family Court, Jajpur, shall remain stayed till the next date. Yes.
Item number 3.
In this case, petition challenges the order dated 30/10/2023
Yes.
Terminating the petitioner. The fact of the case matter, the petitioner was appointed the one.
Prayer, I find there are two prayers. One is you are challenging the order of disengagement
termination.
30/10/2023
My lord,
and to arrear salary from 28/10/2010.
did not get any salary.
So how can these two, they are separate cause of actions. How can they be combined? How can they combine one writ application? Yes, Mr. Das,
Yes,
have you gone through the prayer?
yes.
There are two separate cause of action.
Termination does it.
Termination is all right. Termination, if you have to challenge either of them
My
in one writ application. So how can both be joined in one single writ application? One is you are challenging the disengagement.
No.
That was passed very recently, 30/10/2023. And you are giving arrear salary from 28/10/2020. On what basis?
So joining.
He had also represented before the,
No, but this is not maintainable. In the present form, you ask Mr. Das.
he may confine to one of the prayer.
No, let his senior come. Let his senior. He may be misunderstood. Let his senior come. You ask Mr. Das to. I'm passing it over, or I'll call it. He's available in the court.
Huh.
Then call him.
Huh.
Yes, pass over.
I don't know, 4.
What's
The lordship kindly taken on Monday. My lord has seen as yield today, my lord.
Alright.
Only
the
play Monday.
2009 matter?
Only play Monday, my lord.
Part and matter.
My lord.
Monday को कौन सा? देख ले. अच्छी. Good. Alright. As requested on behalf of Sri K.K. Swine, list this matter next week on Monday.
Oblige, lordships.
I don't know, 5.
Doesn't matter, the lordships already had and only to posted today regarding fetching of final order.
That matter.
My lord, yes.
Where the report was called for, where he says that it was issued from this office, but it is not correct.
Yes.
Is it?
And sub-collector came to an opinion, my lord, that it is false one.
It is fraud.
And accordingly, the decision has been taken not to.
So we'll close it. We'll close it. Mr. Chatwal, you have already heard.
Yes.
Hearing concluded, judgment reserved. Parties may file their note of submissions and memo of citations, if any, within a week. Yes.
I don't know, 6.
Yes, Mr. Acharya.
My lord, just that item 11 also same. So item 11 is same also. Also on the last date, also direct.
Well, yes, whether that enhancement will amount to.
The same day notification टा अपन कहते जे पढ़ी के check whether you have to challenge. You also kindly see the last paragraph that
Of that notification.
notification.
Do you have a copy of it? Yes.
The intention of the granting.
The last paragraph.
Again, last page ro first paragraph.
Okay. The intention of granting.
Intention of granting time scale is to remove stagnation or give incentive to an employee after working the prescribed years of service or more in the same post grade, which means the post grade carrying the one scale of pay. Then you also kindly see paragraph 2 of that notification.
Paragraph 2, yes.
Again, to relieve stagnation. To relieve stagnation and provide avenues of advancement to those who have not been able to move to higher grade for want of promotion opportunity. A scheme of time-bound was introduced for the under the ORSP rules 1985 first. Similar benefit of TBA has also been provided under ORSP rules 1998. So my submission that because it is to remove stagnation,
Read the next line. Read the next line.
again. The TBA scale is basically meant to provide financial upgradation before regular promotion posts are available. Hence, for determining the eligibility and employee of the benefit of TBA scale, the following guidelines and qualifications are issued. So my submission into that aspect that because it is to remove stagnation, the next sentence is not applicable to us because it is for remove stagnation. To conjunct this, my lord, I am just also kindly see the 1985 rules. That is because that is the first come.
RSP.
Rule 9 and 11.
Rule 9.
Again.
Yes. Fixation of pay in the advancement scale shall be made in accordance with the provisions of Rule 74D of the Odisha Service Commission.
Provided that fixation and that. Then also kind of see Rule 11 provides.
Rule 11 provides.
Again.
The next.
Provided that. Just I reading provided that where a result of grant of advancement under the rules, pay of a government servant junior to another government servant in the same cadre becomes higher than the pay of the senior shall be
Stepping up.
So that now, because it includes the pay on the question of
Stepping up is allowed.
So it is included, it is not initiative. Once initiative means not included in the pay. It is just kept apart, just like green card benefits. So that is only clarification. Like other things you have discussed.
I think I've heard enough.
Yes.
I'll close it again.
Again.
Hearing concluded.
Unlimited submission, relying upon that particular decision, it is an incentive, it is not an general income.
That green card thing.
That decision, he has also valid by.
What he says. And I'm not saying that I'm accepting it 100%, but there seems to be some force in his submission that if you look at the entire scheme of this financial upgradation, which is as per this ORSP rules, then it cannot be simply brushed aside as a incentive. It is a additional dose by which your the entire pay structure goes up.
Yes, ma'am.
That is why there is a stepping up formula also has been provided.
Yes, ma'am. But for that reason, my lord, that is in the year, my lord,
Incentive is a reward.
my lord, what he is relying on? My lord, what he is relying on? My lord?
Mr. Patel, let me.
My lord, only one clarification with the lordship's permission.
Yes.
Just now, what it has been placed before lordship, my lord, that is of 1985 pay rule. That
98 में तो शायद हो
Nah, that has been extended to the non-government aided college.
No, even otherwise. Let us even otherwise. Just
only for government, not for
even otherwise. Let us see. Let us crystallize the question even further. What happens is, as I told you, there's a different. What is incentive? Incentive is a reward.
Yes.
Incentive is a one-time reward done for given, but having done something. What is the meaning of incentive? Dictionary. Dictionary have the Oxford Dictionary. Right. I'll find out. I'm closing it. Yes, closing. I'll go through the dictionary meaning. I also.
My limited submission, my lord, relying upon this 1985 pay rule, the benefit was extended. But after introduction of 1998 rules, thereafter, my lord, 2008 rules, up to 2017 rule, my lord, the MSB benefit has been extended to them, but these two benefits, that is TBA and SCP, under the two different ORSP rules, that has not been extended to them. So the 1985 rule, what it has been interpreted before a lordship now by passing it, now that has been extended to them.
No, it was not extended to.
I will ask you to file a written note.
Yes, copy to me, man. That I.
Hearing concluded. Copy of note or copy कौन दबी चीज़ देवे
से जो कोतारा क्वेश्चन सेटा को जब क्लैरिफाई करबे 85 रे दिया है एक्चुअल दिया है 85 तो
then I'll adjourn it again. I'll adjourn it again. No, if you have something to say,
just
let it be adjourned.
Now,
Yes.
hearing may be concluded, madam.
All right. Hearing concluded, judgment reserved. Parties may file their note of submissions and memo of citations if any within a week.
again.
Encourage something to do something that is.
Yes,
Again.
it's a reward, as I said.
Yes.
So item 11 also, Mr. Asha.
Again, same.
Item 11.
What are the divisions? It is Olga post, but claim is same.
Item 11 कर दो. Yes.
Item number 7. Your lordship can have a look to the writ petition, that is WPC 16151 of 2019. What is the basis of this the subsequent writ application where my lords have come? Your lordship can have a reference to OJC number 3837 of 98. Your lordship have called it that record is there.
Yes.
I would bring my lordship the order passed. The writ application bearing in that case. Can my lord will bring to the prayer made in that writ application by these petitioners?
Yes. Who were the petitioners there?
four of the petition, all petitioners were also petitioners along with others.
All right.
You'll also kindly come to page 17.
Yes.
Directing the opposite parties 1 and 2 to grant the petitioner the senior lecturer scale of pay on completion of 8 years of service in case of non-MPhil and non-PhD candidates, and to grant that will be PhD and MPhil, not a and grant the above scale of pay to MPhil and PhD candidates after 5 years and 13 years of qualifying service, basing on the date of appointment of the petitioner, as has been approved by the opposite party number 2 by the annexure 1 series, and apply the ratio of the principle laid down by this honorable court in OJC number 4912 of 1993, decided on 13/12/1996, and according to that, my lord. You'll also can have a look to the petitioners were in that writ application were not only appointed by the managing committee, but their appointments were also approved with effect from the date, and they are you'll also that date that I have given a chart in annexure 4 to that writ application. I have indicated. What? 2018. Then and it was a reference. Original customer here is 2019. कौन बुझ पालिन सर 19 साल में no no that is a part of matter that continue करूची that was to be mentioned कसला सर
2014 पर्यंत होते सर
which was hard earlier.
No, this was reserved for judgment and I brought it under to be mentioned. I think that then I can hear
That's
from.
what you need to know.
I'm not, but I'm just pointing.
I know that. That will be raised because some complications are there so far as you are concerned. You also can have a look to information sheet I was attached as annexure 4 in that writ application. You also kindly get it at
Yes, I got.
yes. Serial number 1 is the opposite, is the petitioner number 4 in the subsequent writ application. And serial number 4 is the petition number 2. Serial number 6 is the petition number, serial number 7 is the petition number 1. And serial number 10 is the petition number 3. My lord, they have given the data. You also can have a look to initial date of joining. I will take one, serial number 7 for appreciation of the fact. Opposite of the petition number 1 of the present subsequent case, date of joining is 7982. Date of valid appointment is 16183. That is with effect from that date the approval has been made. Then, my lord, the director of then the grantee, etc., then he is entitled to come within the selection grade scale of pay from 1/6/1996, reference to etc. My lord, this was there before the honorable bench. In that writ application, you also can have a look to paragraph 5 of the writ application at page rolling page 9. Paragraphs 5, 6, and paragraph 7 also.
Yes.
The petitioners who were initially approved under the state scale, however, were brought into the UGC scale of pay on the introduction of UGC pay revision rules, which was extended to the employees of the aided institution with effect from 1/1/1986. Accordingly, the salary component of the petitioner was duly revised by the competent authority under the approval of the opposite party number 2's office in the scale of pay 2,200 to 4,000, which was the UGC pay revision scale, and petitioners are put to the above scale of pay. It is pertinent to mention here that the may skip over that. That I have given description where is all these things that then you can come to paragraph 6. That it is respectfully submitted that the state government on principle decided by letter number this dated 6/10/89 to adopt the UGC pay revision norms, and the same was also after little clarification accepted and extended to the employees of the both aided and government institutions. Under the instructions issued by the state government, it was categorically mentioned that the college teachers who have put 5 years of service is entitled to senior lecturer scale, and who have put 16 years of service are entitled to the selection grade lecturer scale of pay. It was further stipulated in the said resolution by Annexure 3 that if such teacher has acquired higher qualification such as MPhil or doctorate, to his credit, the qualifying service per computation of grant of senior lecturer skill and selection grade lecturer skill of pay to reduce by 3 years, that is 5 years of service for the former grade, that is senior lecturer skill, and 13 years for the selection grade. So far as the petition number 7, etc., how they qualify, that has been described. Thereafter, my lord, we kindly see page 11. But that is the, be that as it may, the petitioners have acquired the necessary qualifying service to their credit, so as to come within the prescribed yardstick to get the senior scale as well as selection grade scale. It is respectfully submitted that the resolution dated 6/10/89 by Annexure 3, a condition was imposed by the state government under the explanation appended thereto. Count the qualifying service from the date in the post was eligible to receive granting aid, and thereby the valid service rendered by the lecturers for their initial date of appointment, which was duly approved by the competent authority until such post is put to the granting aid, was ignored. This has created a good deal of discrimination in between the lecturers appointed in aided institution and lecturers appointed in the government institution. A writ application was filed by some of the college teachers of the said institution before the Honorable Court in OJC number 491/1993, challenging the explanation appended to Annexure 3, denying the qualifying service rendered by the teachers from the date of duly approved appointment till the post was put to the granting aid. This Honorable Court, by judgment dated 13/12/1996, was the provisions of the explanation appended to the notification by Annexure 3 and declared that the qualifying service would be treated with effect from the date the service are approved by the competent authority, and such date is to be taken into consideration for computation of 8 years, 16 years at the qualifying service for grant of senior lecturer scale, selection grade lecturer scale of pay to the employees concerned. The state government, however, challenged the decision of the Honorable High Court decided on 13/12/96 in a special petition before the Honorable Supreme Court of India. The SLP civil number 9140 to 9142/97, the lordships of the Honorable Appeals Court in their order dated 7/5/1997 dismissed the special petition, and thereby the judgment of this Honorable Court passed in OJC number 49124, etc. was upheld. It is for the better appreciation of the case, operating portion of the order passed by the Honorable Court in judgment letter is quoted as hereunder. In that view of the matter, that's the quotation of the judgment, my lord, the operating portion. The writ application succeed. The opposite parties are directed to compute the period of 8 years in the matter of granting career advancement and other benefits from the date of appointment as approved by the competent authority, and allow them to enjoy the said scale of if other conditions mentioned in order dated 6/10/89, particularly clause 3.7, therefore are fulfilled. Further, it is clear that the explanation appended to the resolution dated 9/3/90 is invalid, inoperative in the eye of law, so far as it defines the meaning of a word regular appointment. Your Lordship, thereafter, paragraph 7 also I am emphatically pressing that in view of the above settled principle law, it is pertinent to mention here that the petitioners were appointed have been duly approved by the opposite parties 1 and 2 by the Annexure 1 series, are to be treated to have been validly appointed with effect from the date of their joining. It is pertinent to mention here that petitioner number's appointment was approved from 1 and 79. the minors can skip over from which that has been there. On a bare reading of Annexure 4, it will be seen that all the petitioners are entitled to senior lecturer scale with effect from the day with effect from the dates mentioned in Annexure 4 at column 12, and the selection grade lecturer scale as per column 13. The state government, after being unsuccessful on their attempt to alter the order passed by the Honorable Court in OJC number this, in a common judgment dated this, issued instruction to the principal of different colleges for submission of necessary information for grant of career advancement of the teachers of the non-government aided colleges as per the UGC norm. A letter addressed to the opposite party number this, dated 15/12/93, is annexed to this writ application as Annexure 5. Again, the opposite party number 2, by letter number this, dated 95, sought for information in a form of prescribed by the opposite party number 2 in letter dated 1/3/97. Also, another query was made by the opposite party number 3 college. In response to the above letter, submitted necessary information by requesting the opposite party number 2 to grant career advancement scale in favor of the petitioner. The petitioners have reliably learned, after receiving all information from the opposite party number 3, the opposite party number 2 has made necessary verification of the relevant documents submitted by the opposite party number 3, and being satisfied that the petitioners are entitled to senior scale and as well as selection grade lecturer scale in accordance with the UGC pay revision and in a consistent to the career advancement scheme as prescribed in such pay revision rules, recommended to the opposite party number 1 for approval and as well as for grant of necessary funds to be released in favor of the petitioner, but no decision has taken. Paragraph 8 is very important, my lord, according to me, that it is respectfully submitted that under Rule 9 of the Recruitment Rules 1974, every employee of the aided institution are entitled to receive the same scale of pay and allowances as are permissible to their counterpart in the state government establishment. The counterpart of the state government counterpart of the petition in the state government establishment, that is the state government college appointed at a point of time when the petitioners were appointed, are enjoying the benefit of senior scale of pay and selection grade scale of pay, reader scale. The inaction of the authority, that is what my prayer was. Your lordship can have a look to the order, the judgment of this honorable court, which was upheld by the honorable appellate court. I have annexed that in the subsequent writ application, which your lordship, after this, your lordship will hear tonight. My lord, to this a counter was filed. The stand taken in the counter was filed on 1st of September 2014.
There is no counter on record in that case, that OJC.
That counter line said
No. Nikhla, physical file Nikhla.
1/9/2014, the counter was there, and I also filed a rejoinder there too. And ultimately, my lord, a stand was taken in the counter. Your lordship had put me a question on that occasion, which I am going to reply in this process. Your lordship can have
the counter. Scan copy रे नहीं, physical copy रे थी वो, नहीं, किन? Counter file लीजिए, rejoinder file लीजिए.
In which case?
13837 of 1998.
Yes. You have that record?
That record is also.
नहीं, record.
Sir, बोला था कोई इतना भी नोट रहते हैं, that will come along with that.
Sir, as you said.
नहीं. Counter is not on record, sir.
Because the plea was taken by in that counter, unless my lord will get that counter, cannot get the
No, but let me
plea of in that counter.
consolidated consolidated amalgamated index जोटा फाइल काउंटर था कि सब जो सीधा नहीं इतना नहीं दिखा रिकॉर्ड है वाला फिजिकल रिकॉर्ड हाँ नहीं फोटो कॉपी ठीक है उसकी
3 pages, 3-4 pages counter, but that should be there on the record because
could हो ये तो देखो The order sheet does not show that any counter was filed.
To that, my lords, I also filed a rejoinder.
So certainly, unless a counter is filed, how will you file a rejoinder?
Yes.
So definitely a counter, but it is not there in the record. And the order sheet doesn't show anything, not even the office note. So can you please say the date on which the counter was filed?
Yes, my lords, the counter was filed on 1st of September 2014.
You, Mr. Patnaik, you find out you must be having a copy of that brief.
Well,
You
in
cannot do that.
2018 case, a counter cannot be filed in the year 2014.
Which is
Again,
98 matter.
JC matter, madam.
Yes. OJC 3837 of 1998.
That file is also not.
So you bring that file.
Yes, madam.
Bring that file. So we'll take it up next week then. If you say that the counter is necessary.
Yes, very much, my lord. Because
we mentioned that,
clearly written in the subsequent case that 4A, 7C, 4A and B was also there before the Honorable Single Judge, the collateral bench. It has gone into, and after that the Honorable collateral bench has passed an order. Manus can see for 2 minutes.
Yes, yes.
What was the direction given by this Honorable Court? Your lordship can have a look to, and how the Learning Secretary has appreciated the matter.
Yes, I have the judgment before me.
Your lordship can have it. The judgment that was passed by this Honorable Court. Annexure 1. On 17th of 1st, 2019.
And that was the earlier judgment which you had referred to in while placing the paragraphs of the rate application.
Yes.
That judgment has been referred to and matter has been disposed of.
No, my lord, that has not been referred to. Your lordship, I'm going to place that part. Where your lordship have categorically directed. Your lordship can come to page 24. Prior to that, page 23.
You come to the judgment because I am opening the other brief, so the page is missing.
I'll place it, man.
Now,
Or on that, I'll place it.
no, you want that judgment dated 17/1/2019, though?
Again.
So that judgment is before me.
Yes.
But you wanted to also place the counter.
Counter of the other case, because basing on all these documents, this judgment was passed on 17th of January 2029.
Yes, yes. No, it's up to you. If you want to place the judgment, I'm willing to hear it.
The petitioner contended that the case of Sashikanta Mishra versus State of Orissa and others,
Sir, court report chate.
page 23.
No, page ta tike tar missing. You say judgment or internal page ta code. Judgment or co-paragraph.
So judgment of paragraph, first page the paragraph pronoun said. It's a continuous.
Yes, it's a continuous paragraph.
It starts from page
That in the cases of Sashikanta Mishra.
page 23 of the present brief.
All right.
Brief of that means, my lord, the
All right.
that is 161.
Yes.
Third paragraph.
No, that in the cases of Sashikanta Mishra.
Sashikanta Mishra versus State of Orissa and others, OJC of the Vishweshwar Sarangi versus State of Orissa and others, OJC, and Madhavachandra Mishra versus State of Orissa and others. A common judgment was passed by this court on 13/12/1996 against the said common judgment of this court. Though the state preferred special leave appeal, civil etc., the Supreme Court dismissed the appeal, special leave petition on 6/5/1997, and thereby the common judgment of this court rendered in the aforesaid case has been confirmed. Since the claim of the petitioner is squarely covered by the common judgment dated 13/12/96, petition may be disposed of in terms of the ratio decided in the aforesaid. Next paragraph is most important, my lord. The state government considered Sri S. Mishra, additional government advocate, appearing for the state opposite parties, states that since issue involving the writ petition has already been decided by this court, in common judgment dated 13/12/96, rendered in OJC number 4912/93, nothing remains to be adjudicated in the present writ of petition. Therefore, this court may dispose of the matter, directing opposite party number 1 to consider claim of the petition in the light of the common judgment mentioned supra. These are the concession given by the state. Then your lordship can come to the operating portion. All that has been quoted about the order passed in that Mishra's case. Then I'll page 26.
Yes.
In the above view of the matter, then my lord can come to page 25, last paragraph. Challenging the said common judgment dated, they say the state people, etc., especially petition common judgment of this court have been confirmed. Then, in the above view of the matter, applying the ratio decided in this court by the above common judgment dated 13/12/1996, the court directs the opposite parties 1 and 2 to consider and decide the claim of the petition in terms of the said judgment, my lord. Whatever the ratio has been decided in that judgment was the basis for which the opposite party 1 and 2 are to take a decision. Because your lordship have given consider, that doesn't give them a right to sit over the order of this honorable court, the order of the Honorable Appeals Court. But unfortunately, Mr. Secretary, sat over the order of this honorable court, sat over the order of the Honorable Appeals Court, and took a decision of his own, which is contrary to the law established by this honorable court and upheld by the Supreme Court. Not only that, my lord, I bring to your lordship's consideration, if the plea taken by the state is accepted, that 7C, 4A and 4B, given them the rider of taking it to the time of 1986, then how it is, my lord, for other persons in the year 2016 and 17, they extended the same benefit which they denied to us? Is it not a matter of discrimination, my lord? And your lordships have categorically decided that there cannot be a distinction between the aided institution employees who are appointed by the management and employees who have been recommended by the staff selection board or by the director selection. All are one because they are appointed by the managing governing body. They may be sponsoring persons. They may recommend the matter, but the appointing authority is the governing body, and the such appointments are when approved by the competent authority. From the date of approval, it will be taken is the due date of completing the service for the purpose of salary and also the career advancement. If that is the law and they have accepted and they are doing till today, sir, how is that we are deprived? Because your lordship have given the right of the consider, they consider and reopen the matter according to their own way. I'll place everything. Let on that record come on that.
But I'm surprised that I also on that last occasion also I had posed this question. How come that amendment has not been challenged? That retrospective operation of that section.
Might not stand for a moment.
I think Chandra Mishra, Radhakrishnan, Visheswar.
I
had challenged that violation of the rule act.
You have not gone further.
We have not gone, yes, that's right.
You have not gone further.
In fact, that judgment which was upheld by the Supreme Court, without taking the very basis of the judgment, they made the amendment.
The question is, after these things have happened, my lord, to circumvent the order passed by this honorable court, 1998,
judgment, nothing else.
you also can see.
That continuous judgment.
I think so, that is the object.
I am providing a copy, my lord, the statement of objects and reasonings of bringing this amendment.
So we'll consider it next week as you have kind of.
They said that they careful देखिए
I have no
difficulty.
I had closed the matter. I brought it under to be mentioned because that 7C came to my mind. What is your reply that I would like to know on that?
Yes,
so that is why all these things have happened.
Yes.
I can today I would have closed it, but for that you are referring to the counter will be necessary to be gone through.
My lord.
Count up state.
Sir, अपन what a question raise कर ले 7C that because of their statement 7C for A and for B was never considered by this honorable court. And your lordship have made a mention, the collateral bench has not taken into consideration. That was there before the honorable single judge. Honorable single judge has said that looking into the entire of my records, this decision that because the concession was given by the state, sir. If the concession would not have been there, they would have contested the matter. Things would have been different. They agreed that this is the law, we will be abiding, that will be abided by us, and will do according to that. That is why this honorable court categorically directed, taking into consideration of the case that has been decided, you take a decision accordingly. It is not to given that you open the field and you go on doing whatever you like. Your lordship knows that particular secretary. He was going to create everything. I do not understand why. If the law has been established, your lordship have categorically given a direction. Taking that into consideration, you take a decision.
On a lighter note, he belongs to our area.
Exactly, sir.
Princely states are.
Whatever the things are, my lord, they think that is the best.
Princely states are.
Yes.
I remember that case. Of course, Mr. Rath was also there. The judgment was passed here. Contempt application was filed. Secretary was directed to present next day, coming day. Then on that day, he could not be present. He was there very much in the Advocate General office, but he couldn't. And I know the bench directed that at 2 o'clock this matter will be taken up. He came and made apology that we will implement the order today.
Sir, no, we have produced 3% from that place. Who are like that? We cannot help it. We cannot help it.
Next day, the amendment, that means the audience was terminated and ultimately this was
Place the objection reason. It has got nothing to do with this. Objection reason of this amendment of this.
But why should the court go into these things now? You will go by simply by whatever has been decided in the previous application.
Yes.
Anyway, but you think, but there's no counter in the main file. Say that is surprising.
That I'm surprised. How it is not there?
Index is you have a copy. If I am calling it on Monday, you please bring your copy. If there is a counter in your brief.
Can it be taken up on Thursday, my lord?
Yeah, I want to call it from.
Sir, rejoinder is there. They have accepted.
I think, my lord, the office could not trace it. Well, that is why region, my lord, they did not.
All right.
Me.
In course of hearing, Sri J.K. Rathal and Senior Counsel, while referring to the connected rate application, that is OJC 3837 of 1998, submits that a counter affidavit had been filed in that case by the state government, against which he had filed a rejoinder. So, the copies of the counter and rejoinder are not available in the case file. List this matter next week under the heading to be mentioned.
Yes.
After a to be mentioned, it is under the heading to be
That
mentioned.
is the mistake of the.
See, hearing
That is the mistake.
he
In all those, your lordship have indicated in the same list that is to
under
be
the same
mentioned.
heading. This is matter next week. So it will come on Friday,
Yes, ma'am.
next Friday, which is on 19th.
Yes.
Correct.
Yes, ma'am.
19th, sir. Yes.
I'll bring on that day, man, is the objects and region, how the object regions are something, and enactment something, and secretary understood is something.
The secretary's order can be considered, but whether
I am not challenging because since that was not a part of this, I am not challenging. I am challenging this that secretary cannot go beyond the orders passed by this honorable court. He is within that.
yes, sir.
Item number 8.
Please, your lordship. Petitioner applied for the job of Shiksha Sahayak. Lordship may kindly turn to page 20.
Is a method matter? What are you challenging, sir?
Non-appointment of the petitioner. Your lordship may kindly turn to page 23
23 of the brief.
of the writ petition.
Yes. Oh, that
He has
physical handicap certificate. Yes, yes.
permanent 40%. In spite of that, and
I have heard it. I think I just wanted to keep it like that.
Yes.
You will close it. Just the person was a physically disabled candidate. She was asked to appear before the appellate board.
They referred it. Only, I will only place 3 lines.
Come on.
Page 24 the contour.
Page 20.
The candidate is coming under PH category and has appeared in the counseling session today, that is 13/4/2018. Should seek clarification from the concerned medical board. She will be, I again repeat, she will be appointed later after approval of the medical board.
Yes.
Medical board has given that they are stopped from taking any other view of the matter. At no cost they can do that, and that they have been doing. Then that is why I also submitted that some cost should be granted in my favor, and cost must be also awarded against the officers concerned.
All right.
I have submitted a detailed note along with status.
All right, hearing concluded, judgment reserved. Parties may file their note of submissions and memo of citations if any within a week.
Item number 9.
This is a matter, of course, I am appearing for the opposite parties, but the matter was hard. Also look to the other seat. In fact, I had given my reply. Then the other side counsel said that I will give the reply. But thereafter the matter was
On behalf of Mr. Swain because of illness of his wife.
But that is a different matter. This is all right, but can I worship take up one day at least to see, because you also see the interim order is operating.
I know. Where is Mr. Das? Where is Mr. Das? Das is not there. You can do one thing, sir. You can leave your associate with there. Mr. Das, let him come so that I'll fix a particular date.
A particular date. So that
Yes.
matter can be at least next week. Any date you also fix, I will talk to Mr. Swain because Swain's stand and my stand is same.
Same.
So that I can talk to him. If he agrees, then I can also do that case.
Where is Mr. Das, junior?
Last one is where?
Yes, he was here for a short time.
Associate also.
We have already filed a counter, my lord.
Yes. No, it is only to be heard.
Only
Wait for some time then. Let him come. Let him.
I will be there.
You can do one thing, pass on the message to Mr. Das. Let him ask him to come. Already he has another matter passed over. Yes.
Hearing Satra.
Item 10 টা sequence mention করছিল না? Item 10.
My landlord said that the matter of 2020, but it was referred to other bench, but again the matter has been assigned to you also because you also had this matter on.
No, I think it will be better if you wait for some time. If he come. Yes, what is this matter? 2012 matter?
This is a case of Anganwadi workers. And the petitioner is appointed as Anganwadi worker of.
Yes.
Petitioner is appointed as Anganwadi worker under Avika Divya Center under Satyavadi project.
You have a dead chart. Let us see the dead chart. Please the dead chart.
Dead chart is not directed to standing to file the dead chart, Lordship. Last occasion, Lordship.
No, there is a dead chart on record. Who has filed it?
We have filed it.
No, the petitioner has filed it. Another dead chart is there.
By the petitioner.
My dead chart is.
Opposite party number 1 has also filed a dead chart. Is there any difference between the two? The dates must be the same.
Some dates have not been mentioned.
Let's hear the same. Let's take up the dead chart by the state. Place it. 30/12/2009. Notice number 8. Inviting application for. You are the private opposite party. Yes.
On behalf of.
Yeah, not sorry.
Shall I place it?
Yes, please.
30th December 2009. Advertisement dated 30th December 2009.
Yes.
Then 15/1/2010, total 8 number of candidates applied for the.
No, only 3 applications will occur. 15/1/2010. You have mentioned only 3 applications.
No, that is actually mistake of Indian Lordship. And because.
No, the dead chart. I am reading from the dead chart.
Well, the date.
The opposite party stated Lordship that 3 applicant.
Who is the opposite party number 1?
Opposite party Solomon party.
You are the private opposite party.
Private opposite party.
Where is your dead chart, sir?
And he has stated.
No, I will go to the state dead chart. Give a copy. Later I will do.
Copy has not been covered, but I have a copy with me.
What do you want?
Says 2000, February 2020. Then 15/1/2010, my total 8 number of candidates applied for this head post. 16/1/2010, scrutinization of documents could not take place. 18/1/2010, CDP of Satyavadi issued another notice indicating that the revised date of acceptance of application would be on 30th January 2010. Then 19/1/2010, the CDPO Satyavadi issued a clarification that the extended date for submission of application fixed by notice dated 18/1/2010 has been withdrawn and no new application will be received. Scrutinization of application will be done on 1/2/2010. That is in terms of the previous order.
So the extension of cutoff date was again taken away.
Again taken away.
Yes.
On 1/2/2010, the CDPO scrutinized the application submitted by all 8 applicants and invited public objections, if any, on or before 8/2/2010. On 1/2/2010, Swarnaprabha Tripathi approached this honorable court in WBC number 2140 of 2010, asserting the advertisement dated 18/1/2010. 18/1/2010, my lord, the subsequent extension. She challenged.
Which was withdrawn subsequently.
On 19/1, my lord.
Yes.
On 22nd February 2010, my lord, this honorable court disposed of the writ petition, giving liberty to the petitioner, that is Swarnaprabha Tripathi, to file an appeal before the sub-collector Puri for selection of engagement of Anganwadi workers made in the meantime shall be subject to the result of the appeal. Then 8/3/2010, Swarnaprabha Tripathi approached the sub-collector Puri by Anganwadi appeal number 22 of 2010 with a prayer to cancel the advertisement dated 18/1/2010 and to act as per the merit list prepared on 16/1/2010, wherein the applicant has been selected for the said post. 12/4/2010, the CDPO Satyavadi addressed a letter to the sub-collector Puri stating that merit list has been prepared taking into consideration application received within 15/1/2010. Then, my lord, Srimati Pushpanjali Malik stood fast. The date has not been provided, my lord.
Pushpanjali Malik is the petitioner.
The present petitioner.
Yes.
In the select list, whereas Srimati Swarnaprabha Tripathi stood 8th in the rank. However, due to pendency of the Anganwadi appeal, appointment letter was not issued. Then 30th October 2010, Sub-Collector Puri disposed of the Anganwadi appeal, directing to stick to the time period stipulated in the first advertisement dated 30th December 2009. The Sub-Collector disposed of the appeal under an impression that scrutiny date is to be taken as 16/1/2010 and the applications received within 15/1/2010 are to be entertained for the preparation of merit list.
So the original one is taken or the subsequent one?
That is the subsequent one, that is on 18/1, extending up to 30th. That has been withdrawn on 19/1. However, fact remains that no such scrutiny of document took place on 16/1/2010. Rather, it was done on 1/2/2010. As per the first advertisement, my lord, the document scrutinization is to be made on 1/2/2010. And accordingly, there was no deviation and it has been done on 1/2/2010. Engagement letter was issued in favor of Srimati Pushpanjali Malik by the CDPO Satyavadi. Srimati Swarnaprabha Tripathi filed Anganwadi Miss Appeal number 6 of 2011 assailing the engagement of Srimati Pushpanjali Malik. CDPO filed her response refuting all the allegations. CDPO categorically denied that the appellant was ever selected on 16/1/2010. ADM Puri allowed the appeal and CDPO was directed to issue appointment letter in favor of Swarnaprabha Tripathi.
So, as it appears, the private opposite party had applied during that extended period.
No, the private party came, the petitioner applied in extended time period. Because it is completed wrong, because CDP was already been admitted in either before the sub-collector and also ADM.
No, let us go to the sub-collector's order.
Sub-collector, also I am reading the sub-collector order.
Sub-collector na ADM?
Because sub-collector is very misrepresented by the Swarnaprabha party in before the ADM, and ADM has the wrongly passed an order because you have to apply for it. Why the ADM has the wrong to pass an order? Because I am reading the SDP order is SDP order is separate order ଅଛି Annex 1 ଅଛି page 8 ଅଛି. In a report of the CDP Satyavadi has submitted that no fresh application has been received in respect of the advertisement on October 2012. She has further submitted that the selection will be made on the basis of the advertisement on 30/2009. The last date of receiving application was 15/2010 and the date of scrutiny was on 16/2010. The CDP Satyavadi has entertained application received in due date on 15/2010 and the merit list will be prepared as per the result of scrutiny held on 16/2010. And by this way, the apprehension of Srimati Swarnaprabha Tripathi of private party, opposite party number 1,
the present applicant that she will be deprived of a claim does not arise. The sole power of the appellant is also same. She has no objection of the scrutiny. She and very important thing also we had mentioned in the separate motion. At the time of the objection, the opposite party has not filed the objection. And she has mentioned that has been mentioned. She has no objection. If the scrutiny that is taken on so like these others and the application received within considering these others are entered for the preparation of merit list. So also in this case, the ADM party, the sole property party, private property party has filed an appeal. It will challenge this order and private property party has I think that in the incorrectly and wrongly mentioned, the city pro submit that is mentioned in page 15 logic. Annex 3 page 15 logic.
Yes.
The city pro submitted a report by the 1414 dated March indicating that it there in that mistakenly it was mentioned that fresh application to be submitted by 30 which has been correct and no fresh application has been received. And the was mentioned is what that is in which ground that is problem. The only application of the present appellant has been received during the due date. These are those. In city for Satyavad they submitted logic so calls and he has clear mentioned because that is a simple case. Because he has there is not understanding the ADM because that misrepresented because misreading also in the code ADM code nothing that is incorrect as that has been mentioned. And city was mentioned nothing. Letter number 1415 that accordingly only applications.
Where are you reading from?
Because it is a
Where are you reading from? Where is that document?
that is the report. I am not analyst logic. Because that record has been in because city project that is huh? Pardon?
The report of the city was issued to you.
No, because that is in before the software logic.
How did you get it?
Because I have collected the software because the official is software. And that all the never certificate copy and page do. Nobody just rocky certificate copy. Because record of no, certificate. কিন্তু রেকর্ডটা আসিছি কর্পোরেট রেকর্ডটা No, because also I corporate certified copy and I will publish that because I will publish.
Which you are not obtained relationship.
Yes, Lord.
You are senior enough to understand that.
Yes, Lord.
Pardon,
Lord.
Anyway,
Last occasion, direct to produce all the record from the CDP office and the record kept in the yeah, ସେଇଟା ଅଛି ଆପଣଙ୍କ ସେ ଏ ଡକ୍ୟୁମେଣ୍ଟ ଅଛି ଆଜ୍ଞା
May I submit, my lord, on 16/12/2023, the lordship directed state council to file their counter. They have not filed their counter, and you also your lordship also directed to produce the record. Your lordship has observed in order date 16/2/2023.
So, yes.
This case, man, we have collected all the documents. We'll value.
Yes, 2 pages.
Yes, ma'am. Yes. Yes, ma'am. Problems.
Item number 12.
Item 9.
Item 9.
Yes.
Yes.
Yes, sir, I am ready. I have already completed virtually. Partly, almost completed. I'll just recapitulate something thereafter.
In connected cases.
Yes, sir. Two cases. In one case, Mr. Swai is there. I am, he is the opposite partner number 4 in the my case, and he has filed an independent case. Yes, yes. This is, I am challenging. Essentially now, the initiation of proceeding by the sub-collector, styling himself as the secretary, president governing body or the governing body. Because the recent judgment of this Hon'Ble Court, a very recent judgment, when I was arguing, this case was not there, but another division judgment was there. Now it has come out also, the sub-collector. Yes, they following that also a current judgment. It is by my Lord Justice. Again. Okay, my Lord.
Because he had
It's never definitely 10, page 32. Directed the sub-collector to proceed against the petitioner. At that juncture, I have come. And in the meantime, during pending of this, because that charge sheet was never served on me, in the counter affidavit, the opinion number 4 has filed this document, so also the government. That is why I called the amendment of the writ petition and brought in this annexure 11A, page 34, which is a proceeding instituted by the sub-collector. As on date, there is no approved governing body for the institution. So therefore, the sub-collector cannot function as the sole governing body because of that Satyasai judgment and all. Reliance has been placed on a letter wherein the sub-collector was directed to take over the charge of the governing body as a special officer. That was the argument also, and that was the document filed. But after that, that was the order. My Lord, get it as page 55 of the counter filed by the opinion number 4. 18/3/2020.
No, annexure ta kaun tha? Page number
Sir, M/4, M/4, M Madras.
Yes.
That is the order 18/3/2020 of the director. Here he has said an exercise power conferred under section 7A3 of the Act. The sub-collector Keonjhar Sadar is appointed the special officer in respect of Anchalika Higher Secondary School, Sirigida, Telkoi, Keonjhar, order to exercise all the administrative and financial power of the governing body of the said Higher Secondary School Junior College under the provisions of the OE Act rules till reconstitution of the governing body said higher school. This is the order was passed in 18/3/2020. But in a subsequent, this is an order by the director appointing somebody as a governing body. Let us assume that he is the governing body. Now kindly turn to page 29. This one 18/3.
29 mane kau jagah?
Read petition. Annex 8.
Page 26.
नहीं amendment ହେଇଥିଲା ତାପରେ ବଦଳି ଏଟା ବୋଧେ old petition ତାର ଅଛି amendment ପରେ 3 page ବଢିଗଲା yes my lord. This is the order of the government notification. It says in the exercise of power under of subsection 6 of section 7 of the Odisha Education Act, pending reconstitution of the governing body of the managing committee, government after careful consideration have been pleased to dissolve the governing body or the managing committee of all non-government aided higher secondary schools, as well junior colleges of Odisha, coming under the purview of the school and mass education department with immediate effect, except the higher secondary school where sub-collector, additional district magistrate have already been nominated as president of the governing bodies. Where the higher secondary school is situated at the district headquarters of additional district magistrate concerned, district shall act
as president of the governing body or the managing committee till further order. In case of any district having more than one additional district, the district magistrate and the collector shall nominate additional district magistrate to act as president of the governing body or the managing committee. Where the higher secondary school situated outside the district headquarters, the sub-collector of the subdivision concerned shall act as president of the governing body or the managing committee till further order. The notification shall come into force with immediate effect. By virtue of this notification, wherever there was no governing body, now they have stated steps will be taken, and the sub-collectors of the ADM, whoever he is, he will be nominated as the president of the governing body. Here there was a nomination earlier, so he will continue as the president of the governing body, but there should be a reconstitution. Because the judgment of the Satyasai or this Baijanti or my lord's judgment in Satyajit Rai Chaudhary, all here that the court has viewed, unless there is a full-fledged governing body with the 15 members or whatever the statutory reform, the sub-collector unilaterally cannot function as the governing body. As per the statute, Rule 21 of the 1974 rule, it is the governing body who can proceed against, not the sub-collector. In absence of the governing body, there is a provision also. Yes, director can, but director power is also limited to that extent. If you read in the final line of the statute, it says if the governing body fail to discharge its duty. Here there is no question of failing the duty because there is no governing body. But from there, only in that failure, the director can initiate a proceeding against an employee. But here is a case that there is no governing body.
So what will happen in case of misconduct?
Misconduct, my lord, the director can suo motu. I would say, my lord, director can suo motu take it.
Because there cannot be a vacuum in law.
Vacuum in the law. But by domination, one cannot function. Even the law is further.
That argument is otherwise.
Yes, but that is also judgment why I am saying all these things. Even if a single person is nominated, now here let us assume this 8/9/2020 order is not there. Because this supersede everything. Even 18(3) order, that this is not there, the 18(3) order stands up to the position. Because now the sub-collector has been directed to act as the administrator of the institution as a special officer. We may say that he is one man governing body. There the law is, my lord, the judgment of division bench judgment of this Hon'Ble court is that if a person is nominated, administrative officer is nominated as a management of the governing body, all his decision, only day-to-day affairs he can take care of. Because it is not such a serious matter where, because there is an allegation that I have been defalcated, I have been all this, but this defalcation, whatever the allegation is, on fact also I will come to, my lord. I have filed the audit report, there is no defalcation. On the contrary, the recent document today morning, he has given me the documents. Now, after the inquiry, director has found that these staffs, those who have made allegation against me, now the outstanding are against them. They have taken advance money. By threatening this principle, they have taken the advance money. Now the director has formulated the points that these are the amounts which to be recovered from the individual employee. So that has to be recovered from all these employees. So I have not defalcated, the audit report is there. That document is there. If my lord permit, I will file it. But the question of law is, if a person is singularly appointed as the management also, he cannot take such a drastic action against a person. But here is that the sub-collector himself has taken the proceeding as a sub-collector. My respectful submission, since the governing body is the authority, they can proceed against, not the sub-collector. If tomorrow there will be a governing body takes up the issue and pass a resolution, yes, I should be proceeded for XYZ charges, then it is all right. That law will take its own course. But the sub-collector has no jurisdiction. That is my point, and these are the judgments. And with regard to the merit of the allegations, what are the charges?
You have already shown that I remember now when you said about the audit report.
Yes,
I was reminded. The last occasion also,
yes, I have seen. I have given the smaller part, but everything now he has given me just today morning. He has passed. I could not file the.
I'll adjourn it, but let us preliminarily hear the senior counsel.
My senior has also
because my point is, I do agree. I have myself passed a judgment saying that he cannot act as the disciplinary authority. Okay. But then there cannot be a vacuum in law.
Yes, that's true.
So that, as you said, it has to be the director.
It has to be director. And for
here, but somehow in passing, probably I could see a document where the director has approved the draft charges.
No.
What would he reply to this?
What he says is, my lord, if the genesis goes, the superstructure will fall. If the charge is framed by an incompetent person, even if it is approved by the competent authority, it will not regularize the irregularity. In that way, I can say. What he says is, Annex 10 may kindly be seen once again. They start like this. He is not approved. He has stated so. Allegation against principal, page 32. I am directed to invite reference to the above noted subject and to say that the Director Higher Secondary Education Orissa has been pleased to approve the draft charges leveled against the Girija Shankar Mahapatra Principal IC Anchalika Higher Secondary School Chigidia in the district of Kenjur for trial of proceeding against him. So what is the draft charges? Annexed 11A. It is by the sub-collector, which has been approved here, because at that relevant time, the charge was not served on me. He has approved the action of an incompetent person. The doctor is at the election,
when an appointing and disciplinary authority decides to proceed against a person,
Yes.
then the office is asked to frame the draft charges. The office submits the draft charge, he approves it, then only it becomes a
that
charge.
is not the procedure. For law is the disciplinary.
That is how it is done, Mr. Das.
How it is done
I'm not saying in this case, in all cases.
in all, my lord, once right officer put the signature.
They frame the charges, they place the draft for approval. Then only it is approved by the authority. I may have done it 1,000 times as a district judge.
Maybe,
The
but
register puts up the note.
with due respect, I can say if the disciplinary authority is X,
He has to apply his
he has
mind.
to do.
No, he will apply his mind. That is why it is called draft. Office, looking at the papers, office may suggest something.
And that is under this particular rule, there is no provision of approval of the draft charge. The approval comes at 22 kindly see at this moment.
Approval, it's an administrative act. I'm just.
No. Director's power. I am here in the director's power. There is no question of sending a draft charge to the director. Director's power, if my lord will see 22, rule 22.
But that's several more rules.
Yes. Where did the director's power come? Only in 22:15. Sorry, 14. 976 page.
Rule kete?
Rule 22.
Rule 22. Proceeding for imposing major penalty.
Major penalty, yes. Kindly see the procedure. They unlike civil that our CC rule.
No, that argument which you say that there is no provision for draft submission. There is nowhere there is such a provision, neither in the OCS CCA rules or even in the central rules.
Because
there is never any provision for draft
framed by the disciplinary authority. So now the person, he is the sub-collector.
No, I don't know what has happened in this case. Academically, we are discussing.
Yes.
Sometimes what happens is, in the administrative setup, the draft charges, looking at the materials, looking at the allegations against the person, the office prepares the file and places it. It is the disciplinary authority, unless he approves the draft charges, or he may add, he may alter, he may have his own view. In this particular case, he may not have done it.
That may be the administrative, to help the authority, the administrative
yes.
hierarchy can do that. But strictly saying in the law, it is the disciplinary authority who framed the charge. So there is no question of draft charge.
So here
there is always charge sheet. Can you see the rule? Let us see. Clarify. Kindly help.
That dispute. No, supposing the draft charges submitted by the sub-collector would not have been approved, then it would have no meaning.
My lord, there is no, in this particular rule, I am confined myself to this particular case. There is no concept of draft charge. Kindly see.
Let me know.
Kindly relax.
Yes,
so I am not going to that. Page 22. Proceeding 996.
Yes.
My lord, proceeding for imposing major penalty. No order imposing any of the penalties specified in clause F to I of sub-rule 1 of rule 20 shall be imposed except after an inquiry held as far as may be in the manner herein after provided. 2. Sorry. The disciplinary authority shall frame definite charges. I am giving emphasis on definite charges. There is no concept of draft charge. It has to definite charges on the basis of the allegation on which the inquiry is to be held, and such charges shall be communicated in writing to the employee concerned, who shall be required to submit within such time as may be specified by the disciplinary authority a written statement of his defense and also statement in the desire to harden so and so. Then thereafter 3 is employee concerned shall purpose of preparing so and so. Next document called for. Then 4 is on receipt of the written statement of defense, inquiry officer and all these things. 5 is the disciplinary person appointed person of rules are in charge may be considered as documented evidence. My lord, disciplinary authority person. Now kindly come to page sub-rule 12, where the director's power comes. 12. These are the procedure, my lord, this normal procedure. 12. The disciplinary authority under sub-rule 2 of rule 21
shall forwarded the records of the inquiry together with a copy of the order passed in sub rule 9, 10 and 11 to the director for his advice. The advice come at this stage, not at the initial stage. And thereafter, on receipt of the advice of the director, the disciplinary authority of the rule shall consider the advice, determine the penalty, if any, imposed on the employee and pass it or so. So only at 12, this days, director's power comes. Before that, it is the disciplinary authority. Here the 21 says disciplinary authority is the governing body. Here is a person, if we will say, as my lord was, it is falling from my lord's mouth, that yes, disciplinary authority, because there is no governing body, director become the disciplinary authority. He has directed X, Y, Z to submit a draft charge. He has put a signature, that means that becomes the charge sheet. You have to explain yourself. So that is, as I have understood, if my
Yes.
but my respect submission is, the rule says it is the disciplinary authority. And disciplinary authority has to form the definite charge.
But what was communicated to you after Annex 12?
Nothing. This 11.2 from the counter. This is 11, Annex 11A. Can you see what it is?
This is not communicated to you. This is
No, this was the charge sheet filed in the. I have amended this petition because this has never been communicated. Only from the counter affidavit of the director and as well as the opposite partner of 4, I came to know about this. Because I have initially challenged Annex 10 only, 10 and 11.
that you have incorporated now.
Enable A, I only from the counter. That was never served. And what does it say, my lord? They are not dispute. They are saying this is charge sheet. Can you see what the preface is?
All right.
It says, page 34, Annex 11A. This is the order of the sub-collector.
Yes.
Inviting reference to the letter of the subject cited above, I am to say that the irregularities committed by Sri Girija Shankar Mahapatra, Principal IC, Anchalik Higher Secondary School, Serigida, Telkoi in the district Keonjhar, has reviewed. Accordingly, draft charges have been prepared against Sri Mahapatra on the following charges. Therefore, is sending herewith the draft charge initiated against the Principal IC. I would request that the same may kindly be approved for the course of action.
So this was approved under Annex 10.
Annex 10. So now kindly come. These are the charges. This was sent. Along with this, the entire bunch was sent to him. He says, I have put a signature to this. Annex 10 says it has been approved. And Annex 11 is another impugn order where they have direct direction that senior most teaching staff will be placed in the municipality on subsequent affair. So my response submission is, first is the initiation of the draft charge. The draft charge was prepared by the sub-collector, styling himself as this special officer or the president of the governing body. My first submission is, he is not the special officer as on 26/8/2020.
Why is that date important? 26?
My lord,
What is that date?
এটা date হচ্ছে 25/8/2020 My argument is twofold.
25/8/2020.
If he is saying that I am the special officer, I am the governing body, so therefore I can frame charges, he could have directly sent it to me. He could not have sent it to the director. I could have replied to whatever the point is there with me. So at that point of time, my submission is twofold for this reason, my lord. On 25/8/2020, though you are the special officer, but in view of the judgment of this honorable court, the division bench judgment of Justice Ella, my lord.
Satyasai. Satyasai.
No. I would division bench judgment, Justice Ella, Janardhan Rao. This is judgment.
Yes.
Here, my lord, this case was relating to a cooperative society. An administrator or government officer was appointed as the administrator in place of the cooperative society. There the action was taken, that was subject matter of challenge before this honorable court, and this honorable court said that you are appointed as administrator to look into the day-to-day affairs of you cannot step into the shoe of the management. You discharge the normal duty, but you cannot take action like this. This is the identical case of same nature. Therefore, even if a special officer, he cannot proceed against me. That may be, had it been so, my lord, had it been so, then he could have, what he could have done, he could have directly proceeded against me. Why there was no requirement to send the draft charge to the director and get an order. That means he was also not sure of the fact whether he is the governing body or not. And moreover here, the director's power is also very limited. Director as a disciplinary authority is something different. There is no power. First, my submission is director has no power to approve a draft charge. That is first. Secondly, director can proceed against me only in one contingency. The contingency is, my lord, page 21. Sorry, rule 21. Rule 21 says
the director may impose any of the penalties specified in Rule 20 on any of the employees, provided that the director shall not initiate any disciplinary proceeding unless the managing committee or the governing body, as the case may be, refuse or neglect to take disciplinary action against an employee. Only in that contingency, if there is a refusal, some action has been taken up by an employee, no action taken by the governing body. So there, in that case, director can step into the shoe of the disciplinary authority and can proceed against the employee. But here is a case, there is a disciplinary authority. Let us assume that special officer of the disciplinary authority. So disciplinary authority is to proceed against. There is no requirement of approval of a charge. There is no prescription in the.
All right.
So we cannot say that director has step into the shoe of the disciplinary authority in this case, in this particular case. So therefore, my first argument was the special officer on that particular date has no power to proceed against. Secondly, my lord, because the government has appointed the sub-collector, nominated the sub-collector to the president governing body, and she is the only one person, there is no governing body constituted. Till a reconstitution is made, he cannot proceed against. He has to wait for a governing body decision to that effect. So therefore, in these two scores, it has to go. And moreover, the allegations, kindly see, madam.
Allegations have already placed it.
Yes.
The
entire allegation is by the staffs. What is their staff? I am not paying their salary. The money of the institution has been misappropriated and all these things, or everything is that money has been misappropriated and all these things. But the audit report I have placed, there is no audit objection. And there is no special audit till date by any other authority that yes, I have been found guilty in that way. That is also not there. And now, because today I have received the documents, that now the defalcation money is found against the employees only, not against the petitioner. Because they have taken advances from the institution, forcefully or somewhere or other. That is why now recovery has been going on.
Right.
So in these peculiar facts and circumstances, I should not be disturbed from the post till
there is an interim order in your favor.
Yes, that is an interim order.
Yes.
So now the second case is filed, and there is another point. The OP number 4 here is admittedly a senior person to me, but he has given a written unwillingness to continue as principal in charge of the institution. That is why I have been appointed. Otherwise, I could not have been. So now the government has issued that written objection. I have filed it at Annex 3, and the government has issued a circular way back in 2015, basing on which all these things, that says once you have given a written objection, written unwillingness to continue, it is for all time to come. And basing on that, on judgment has also delivered by this Hon'Ble Court, that once you have given that in Kalpana Das case, I will give it along with a note, my note. Yes, they did. So there also that has been upheld. But now there is a development. What happened in 2021? Another circular was issued by the government by superseding the earlier circular of 2015. 2015. You have forgone the right. So that now said, no, even if he has forgone that right, now if he wants to continue as the principal, he can also. But that is a subsequent event to this case. So my response submission that cannot have any effect on this particular case and the dispute, because this is a 2020 dispute. This is all about my case. Let them submit, I will give a reply to that.
Sir, you are appealing for the governing body?
No. For that OP number 4, I think.
OP number 4.
I am appealing for the government.
And same person for whom Mr. Swami is appearing. So you have filed a writ application also? And
He has filed a writ application claiming for the principal.
No, you are not for the government. You are for the number 4.
For the private office. Yes. The person who was senior to you and who expressed his unwillingness.
Yes.
Well, before I begin and give reply to the question which is advanced of your lordship with regard to the question of law, let's say kindly come to page 14.
48 of the brief in the first writ application.
This is the writ application. Mr. Mishra's, Mr. Das writ application.
48.
WPC 343 of 2020.
Sir, you will have to refer to the annexure because there seems to be some difference in dates. Annexure really subidha.
Better. Page 14. He has challenged to quash the order dated 22/10/2020 I'm just reading.
Yes.
It is therefore humbly prayed that the Honorable Court may graciously be pleased to quash the order dated 22/10/2020. 22/10/2020 is annexure 10. Then 6/11/2020, that is annexure 11.
Yes.
And by way of amendment, he has incorporated draft charge dated 25/8/2020, annexure 11A. You also look to annexure 10. What is annexure 10?
Yes.
I think your page.
It's annexure 10.
Yes. Annexure 10. This is a letter from the director addressed to the sub-collector cum special officer. I'm using the word special officer because that is nomenclature sub-collector Keonjhar, district Keonjhar comes special officer. Allegation against the principal so-and-so, your letter dated so-and-so, that means sub-collector letter directed to invite a reference and the above subject say that the director has been pleased to approve, which my learned friend again and say that approval. Then annexure 11. Inviting a reference to the subject cited above, I am requested to intimate the name of senior most teaching staff of the so-and-so college to be appointed as the principal in charge. Not that appointed, to be appointed. This is a principal in charge, you also know that. Then, sir, kindly come to the 11A. That is the draft charge. That is the draft charge at page 34. Let's get it. Yes. Draft charge by the sub-collector comes special office. Now, at this juncture, so kindly have a glance before I take your access to the orders of the government or the director, whatever has been placed before us. Let's kindly look to section 7, the substantive provisions of the act. That is, I think your Lordship's book also is parallel to my
Section 7.
Yes, 7 subsection 6. Section 7,
Subsection
33.
Yes.
Every private education institution have a governing body, as the case may be, constituted according to the rules. Let's get it.
Yes.
I skip over. I don't want to take your Lordship's time. Let's just straightway come to section 7(6), subsection 6. The prescribed authority has been defined on section 3, subclause F. As per the rules that we notified here, the prescribed authority is the director. There's no dispute over this. The prescribed authority may allow the governing body or the managing committee, as the case may be, whose term has expired under subsection 4 or subsection 2 of section 7A to continue in office till the governing body or the managing committee reconstituted. Let's say pause for a moment. Or appoint any person, singular, any person or persons to exercise the power and discharge the function of the governing body or the managing committee during the intervening period. The language is very clear. If a term of the governing body expired or it has been superseded by section 7A as referred to in subsection 4 of 7A, then in that case, a person or a body of person can be appointed by the prescribed authority to exercise the power and discharge the function of the governing body. Or the old governing body may be allowed to continue till the intervening period. That you also wanted to know how that intervening period will be managed. Suppose some misconduct or something. So this is the provisions provided under section 7C, which are substantive provisions. And the proviso may not be applicable here, provided that the state government may record to the governing body or the managing committee, as the case may be, notwithstanding the term of the governing body or managing committee has not expired on such record. So it is necessary because I am taking to also that even when the term of the governing body has not expired, the power is conferred on the state government to resolve the managing of the government. Now, you also at this juncture, you also kindly see the prescribed. I don't think I place it. Prescribed has been defined on that is all. Yes, that is prescribed means prescribed under the rules. You also skip over. Then you also kindly come at this stage to the counter filed by the sub-collector. All the documents which are filed by the sub-collector that counter. I will take to those counter. So the counter filed by the OP number 3. Let's say kindly come to page 16.
Page 16.
Yes, sir. 18/3/2020.
Sir, page.
The OP number 3. Counter affidavit.
Annexation টা কেতে କହିଦିଅନ୍ତୁ
So the annexure ଟା ହଉଛି A by 3.
A/3
A by 3. ସେ ଆପଣଙ୍କ ସିଷ୍ଟମରେ କଣ ପେଜ ଗୁଡା ଆସୁନି?
ନା ଆସୁଛି ମାନେ
କି ପ୍ରୋବ୍ଲେମ ଅଛି?
because of I mean Annex A/3 yes
Yes.
18/3/2000
Yes, sir. Even who has passed this order? Director of higher education.
this is because that consolidated rate application has been wrongly scanned at a
This
earlier stage
Yes, sir.
which is wrong.
Yeah, I'm sorry. So this has been issued by whom? By the Director of Higher Education. He is the prescriber. Does you get it?
Yes.
In exercise of power conferred under Section 7A3 of the Orissa Education Act 1969, the sub-collector Kendujhar is appointed as special officer in respect of Ancholika Higher Secondary Schools, so and so in the district of Kendujhar, in order to exercise all the administrative, financial power of the governing body of the higher secondary schools of the junior college under the provision of the Orissa Education Act rules till the constitution of the governing body of the said higher secondary schools. So this is in terms of the provision of Section 7(1) or 3 or 6, where the power has been conferred on the special officer sub-collector to exercise all the powers till the reconstitution of the governing body. Now, at this juncture, I'll take your worships. This is on 18/3/2020. Much emphasis was made to this provision. So at this juncture, my learned friend has enclosed that document in his writ application. He's relying at page 29, Annexure 8. Annexure 8. Because this is I think almost you should come to a conclusion that whether the sub-collector has a power or not, then we'll go to the other questions, sir. So kindly come to page 2, that Annexure 8.
The notification.
Sir, that this is a notification by Government of Orissa Department of School and Mass Education. Okay. Proviso. I've read just now 7(6) proviso. Government. 7(6) principal provision. Prescribed authority. Director. Got it. Director has the conferred the power to appoint person or persons to discharge the duty of the governing body till the reconstitution met. Before expiry of the governing body, the government has the power also to dissolve. Kindly come to page 2. In exercise of the power conferred under the proviso 2 subsection 6 of Section 7 of the Orissa Education Act, pending constitution of the governing body or managing committee, the government, after careful consideration, is pleased to dissolve the governing body or managing committee of all non-government aided higher secondary schools, as well as junior colleges of Orissa, coming under the purview of the School and Mass Education Department with immediate effect, except the higher secondary school where the sub-collector, additional district magistrate have already been nominated as the president. We are not concerned with that president. Here, sub-collector has not been nominated as the president. Sub-collector has been appointed as the special officials. Power is being now exercised under Section 7(6) to dissolve the governing body where the governing body is continuing. Not that the term where it has expired, no governing body has been constituted. Our case is a case, arbitrarily, term has expired, the special officer has been appointed in terms of Section 7(c) principal provision, and this particular notification dated 8/9/2020 is applicable in a case where there was a governing body continuing, the government decided to dissolve it. That is by unanimous. Then next part, where the higher secondary school is situated at district headquarters, the additional district magistrate of the concerned district shall act as the president of the governing body or the managing committee till further order. In case of any district having more than one additional district magistrate, that district magistrate and collector shall nominate one additional district magistrate to act as the president of the governing body or managing committee. Pause for a moment, sir. This is in case for nomination of the president of the governing body. For the purpose of constitution of the governing body or reconstitution of the governing body, in which district the additional district magistrate will be nominated as the president, and in which subdivision sub-collector will be nominated as the president. And in a case where there are three, like Cuttack, there are three additional district magistrates who will be nominated as the president. That is for the government to decide. Then next, where the higher secondary school is situated outside district headquarters, the sub-collector of the subdivision concerned shall act as the president of the governing body of the managing committee till further. Then notification shall come into force with immediate effect on the date of issue. So my respective submission is, I, your worship must have now, if your worship will read section 7(6), both the principal and the proviso. This is a case where power has been exercised by the government in exercise the proviso of section 7(6), and it has clearly mentioned, conferred on the proviso to subsection 6 of section 7 to dissolve the governing body where the governing body are continuing. And in case of dissolution, what will be done? The additional district magistrate will be nominated to the president. Sub-collector in the case of subdivision will be nominated to the president. So far as the power where it has been exercised, a special officer has been appointed and continued, that has not been touched. Am I clear? So that
will give this notification has no application.
Absolutely no application. It cannot supersede the order under annexure, the annexure which I have just now placed people on it. That where power has been exercised on section 7, appointing the sub-collector as the special officer to discharge the function of the governing body. Am I clear?
Yes.
So that cannot.
That document is not on record.
That I just now placed. That I just now placed.
The annexure A by 3. Right.
Yes.
All right.
Oh, they would have note for this. That's not in confusion. Now, sir, kindly come to my writ application.
Page 633.
Sir, his writ application. I am replacing on that writ application. Girishankar Mahapatra 4343. Now, much argument was advanced with your lordships. Sub-collector has no power because of on this contentions. Then the director's power, director has no power to approve the draft list. Sub-collector has no power, therefore the incompetent authority has sent it for approval. These are all arguments your lordship have borne in mind. I say at this juncture, may I take your lordships to just for a minute. उसे पेज में क्यों कर दी सर सिटी के सब
अब annexure कहले हो
हम annexure coach sir ठीक है now yes you also kindly come to that the counter filed by the sub-collector. You also straightway come to page 31. Sorry, page to quite that is annexure C by 3.
Yes.
Yes.
There is a petition.
Yes, sir.
27/2000.
Counter to the counter. Counter filed by OP number 3.
I'm looking at annexure 3 C by 3.
C by 3. C by 3. C by 3. The relevant portion is the allegations. The allegation at page 31 that has been. So only I want to show the one paragraph of the allegation, nothing else. Then I'll take your lordship to.
Yes.
That grievance petition, to whom it has been addressed to the director, and almost all the staffs they have made this grievance. First grievance is they are not being paid the salary, that is one grievance. The other grievance is the EPF amount has not been disbursed.
Non-maintenance of cash book.
That apart from this, another astonishing matter is that two types of monthly receipt book of yellow and white color have been used at our college. Money received in yellow receipt books goes to the college account, where money received in white receipt book, instead of going to college account, rather it goes to the pocket of the principal, which is matter input could be inquired into. In the previous financial year, the principal even was using a forgery yellow receipt book. Then para 6, it noted here that in the year 2006-07, a project so-and-so was supplied from drinking water in the college was granted, but unfortunately, principal has misappropriated amount. These are allegations. I can say this is, nobody can say neither we nor your lordship can come to a conclusion whether the allegation is correct or not. But why I am taking to your lordship's this allegation, then kindly sir come to page that is annexure number that is the letter of the sub-collector dated 25/6/2020. Say annexure.
25/6.
Page hochi 35. Page 30. Tanko counter internal page hochi 35. Say just the thing that
yes. 25/6/2020.
Yes, sir. Who has addressed the sub-collector has addressed this letter to the principal in charge. That means, sir, to the petitioner. Non-maintenance of cash book and use of card of biometric attendance in respect of so and so. In writing reference, I am requesting you to produce the cash book, relevant register relating to maintenance of cash and details regarding use of card of biometric attendance of so and so before the undersigned within a week positively in order to conduct an inquiry into the allegations and negligence in duty of Girija Shankar Mahapatra, is the petitioner, and to submit the action taken report to the Director of Higher Education for information. Any deviation producing document, then kindly come to the next page, sir. In response to this letter to the principal, the present petitioner, the petitioner has addressed this letter to the sub-collector. Next page, page 36. So to the sub-collector, submission of cash book and document regarding biometric attendance with respect to in reference to the letter not subject cited above and herewith submit the relevant record relating to biometric attendance cash book as desired by the director during his visits, because both Director of Higher Secondary Education and also the Director of Secondary Education both have visited made a joint inquiry that is admitted, and they had given a report. On that report, this regarding the cash book was directed to be produced by the sub-collector who was the special officer, and the principal also produced all these records for the purpose of inquiry. So see that why I am taking that submission. He himself was considered to the authority not only of the director but also the sub-collector, because he himself has submitted all the document. Then we also kindly come to page 37. Page 37.
Yes.
You also see who has addressed this letter? None else than the petitioner, lead petitioner. Also say to the director, unless appeal for your direct intervention into my demands for unilateral action against me, though the sub-collector Kendujar comes special officer, in short, through sub-collector comes special officer, all these documents were produced before the director and a representation was made by the petitioner to the director. It will also come to the last page of that letter that is at page 41. Girija Shankar Mahapatra, he has made the representation to whom? Through the director, through the special officer, and along with all the documents. You also see the documents enclosures. That is at page 41.
Yes.
All enclosures. Then after this, then let's skip over. You are not necessary. Then kindly come to page 45. He himself, the petitioner, addressed a letter to the sub-collector accepting in the authority. That is at page 45. On 8/11/2014 in area, that is area.
No, this is to the SP. Sriyukta Arakhi Adhikyak.
SP. Oh, sorry. So to make an inquiry at page 46 to make an inquiry. Then you also kindly come to again page 48.
Yes.
Page 48. Again, the principal addressed a letter to the Director of Higher Education. But you see that?
Yes.
And what is the prayer made in that before the director? Let's come to page 50. Hence, in this regard, I request you take necessary steps, doing proper at your level, so that it will enable me for a smooth administration of the. That is by Girija Shankar Mahapatra, this petitioner, on 15/12/2016. Then, sir, kindly come to, and he has also given the copy of the receipts. Sir, then kindly come to series of letters, then 52. Again, he addressed the letters to the office of from the office of the principal to the, let's skip over. Then, sir, kindly come to again at page 58. That to the director regarding proceeding and action against so and so. He himself has assumed the authority of the director to intervene in the matters and to make an inquiry. That is at page 58 on 18/1/2018. And the second page, next page at 59. Further, I kindly request your honor to visit the institution for an investigation into the matter. Does you get it?
Yes.
That is at page 59. Then 60. He addressed again a letter to the director. Since your administrative there are some correspondence. Since your administrative support and strength are highly essential for me to run the institution, the proceeding case pending at your level may kindly be disposed of by taking disciplinary action appropriate through legal considerations. Then, sir, kindly, all these documents shows that he has addressed this letter to the director as well as the through sub-collector. The last one is sub-collector's letter, sir. At page 69, that is annexed E/3. E/3. I need not repeat those again and again repeated. He himself has assumed the authority of the sub-collector as well as the director. Then page 69. Sub-collector, after making an inquiry, he has he found this. allegation against the principal Anchoika, of course, it is allegation. Letter number swans of the director, sir, inviting a reference to a letter subject cited above, I am to say that the irregularity committed by Sri Girija Shankar Mahapatra, principal in charge in Swanso, in the district of Conduzer, have been reviewed. Accordingly, a draft charge has been prepared against the Mahapatra principal and the following charges. That means, none else, the sub-collector, who is the special officer, he has framed the charges. The Lordship rightly put that question. The draft charge that we have approved, it is not contemplated with the rules or acts, but it has got, where such power is available, I will show you ourselves. And why he has requested the director to intervene and to make an inquiry and all these things, that is from his side. There is nobody. So now the sub-collector sent it, and after that the sub-collector, the memo of charge has been prepared at page 70. Next page, which he has now challenged by annexure 11A. Now, at this juncture, another document I will show to your worship, then I will take your worship to the law. Let's come to the counter filed by OP number 4. OP number 4. Sir, OP number 4 has given a note sheet which has been obtained on the Right to Information Act from the director, from the office of the director, that has been produced, which has not been also not denied. Sir, can we come to page 46? Say page, and that is page. That is annexure L/4. Annexure L/4.
Yes.
Sir, see that I am reading just one or two paragraph. As per the direction of Director of Higher Education, Director of Higher Education is the prescribed authority. As per the Director of Higher Secondary Education, Orissa, Joint Director conducted spot inquiry into the Anchoika Higher Secondary School, so and has reported that. And the report also see biometric attendance to be on fingerprint only, no card to be used, disciplinary action against the Mahapatra may be taken for his negligence, irregularity, and false attendance. Then the change of the so cause to the principal may be asked regarding irregularity. These are the inquiry report. And why the inquiry was conducted, he himself has made the allegation. Director directed a joint inquiry. Both two top officers, one is a joint director, the other one is the additional secretary rank. They both have made a joint inquiry. You also see the joint inquiry report in the top. At page 118, 119, see inquiry report of joint director. Then we also kindly come to page 52 of that Right to Information. Page 52.
Yes.
Sub-Collector Kebujar has conducted an inquiry by his office order number 18/3/2020 on Ancholika Mahavidyalaya Swanso. Irregularity has come into the inquiry committed by the principal in charge, Sri Girija Shankar Mahapatra, and DAP charges have been framed against him in the following: gross negligence and discharge of duty, tampering of biometric attendance, gross misconduct. Sub-Collector has sought for approval of the directors of higher education for the draft charges. Then I will not place those documents already. That is, the draft charge is the subject matter of challenge before lordships. That is by way of amendment. Now, if we look to the provision, so called the power of the director. Let's come to the 1974 rules. It is an added college. Added college that comes under the 74 rules. I am referring to rule 22 and 21. So for we can't say the director has absolutely no power. It's totally without authority of law. But what I understand from the argument advanced by the petitioner that the director could have done, director could not have acted on the basis of an incompetent person's proposal. It could not have done. The director could have. But so far the director power is concerned, also look to the power of the director. Page 999 of your worship, I think in my book.
Yes, same book.
Director's power of revision. Notwithstanding anything contained in Rule 22 and 23, the director may, on his own motion, you also know that own motion has been, Orissa Land for Mark, Orissa State License, any information, or otherwise, after calling up for the records of the case, reverse any order which is made or is applicable under these rules and may confirm, modify, or set aside, B, impose any penalty or set aside or reduce, confirm, or grant the penalty, C, remit authority which is made order, so D. Also, C, D. pass such further order as it deems fit. So my respectful submission is that here the petitioner himself have made allegation, the petitioner himself made request to the director, and that too through the sub-collector, through the special officer, and director directed for joint inquiry. And joint inquiry, this report has come. And on the basis of the joint inquiry report, the sub-collector has also made his own inquiry, and he has framed some certain charges. That's all. Now, certain charges, now he has challenged on the ground incompetence. Then the question now comes to your lordships that if your lordship will come to a conclusion that sub-collector has no jurisdiction, then your lordship will proceed to the matter that whether the director has power or not. If your lordship will say that director has no power, then the question comes that during that intervening period, if section 7, subsection 6 will be interpreted in any other manner, then that the legislature has no intention, cannot have any, said to be an intention that the period will be vacuum. Nobody will be there. But here the argument which was advanced, that annexure A by P is superseded by that one, the other one, which is in accordance with the proviso to section 7.6. Nothing to the principal provisions. So far, the special officer, appointment of special officer to decide the duty has not been touched. Only case of continuance of governing body has been dissolved, and sub-collector, the additional district magistrate or sub-collector who are maybe nominated as the president. That's all, nothing else. Now, your lordship may kindly, so far as first now the question of law, which I don't want to take much time. So a person who has conceded to the jurisdiction, even if that person has no jurisdiction at all, he himself has accepted. Whether he is stopped from challenging the jurisdiction, your lordship knows that I'm giving 1 or 2 judgments to your lordship. So you can give it later. If you I can give it. That is one. You cannot go back and say that with view of the principle of estoppel, you can't say that because sub-collector has no jurisdiction. You yourself has addressed, made representation to sub-collector. You yourself have made the representation to the director to make an inquiry. Director made the inquiry. Now you will say that director has no jurisdiction. Now you will say that sub-collector has no jurisdiction. This is one. That judgment I will give it by lot of service.
I'm not completing it today. I'll complete it next week. I'll complete it next week. For obvious reasons. For obvious reasons. Today, 3 matters have been heard and kept for reserve. Heard further arguments in part. Let's this matter next week. Next Friday. Lecturer.
No, computer program.
Computer.
Working on the university, and the Assam has been ejected on the annexure 15.
Annexure 15. With reference to a letter in the under OUR SP rules 2009, scale of pay attached to the program and further rationalization of your scale. Yes, what was their claim?
My claim is, millards, so far as the scale of pay of the program is concerned, there are 2 different scale of payers there. Accordingly, I approach the authority.
No, you were appointed as
the computer programmer. That annexure 1, page 15.
Yes.
And 2 different scales there in the same cell university. I approach the authority. The authority time and again recommended the matter to the
2 different scales means
one is that is there. One is I'm giving.
You were in the school.
5,500 ଥିଲା ଆଉ 10,500
କେମିତି
7,500 10,900 6,500 10,500 2ଟା ସ୍କେଲ 2 ଜଣ ଦଉଥିଲେ different same category elo se kind of recommend there the authority time and again recommend the matter to the vice chancellor to the chancellor again recommend matter to the government again the government remitted matter to the chancellor said that you are the competent authority again the chancellor said yes you are the chancellor said to the vice chancellor you are the competent to decide the matter. Now again the government the vice chancellor recommend matter to the government, and while the matter is pending for the government, the assistant registrar has no authority out to reject the matters. Even if the matter is pending for the government, pending for the chancellor, pending for the vice chancellor, the assistant registrar, for that sake also kindly say I am pressing the matters. The entire matter is clear from the correspondence made by the authority from times. You will kindly see first page now, annexure 4, page 19.
Yes.
This is from the register.
But how could there be 2 different pay scales?
That is there. They have admitted, and for that sake, rationalization scale of pay that was recommended. That is there, and they have admitted in the letter.
There were other computer programmers like you.
Yes.
different in computer sections, different programs are there. Suppose what I could university PG section, different look, different region. That is their own admission. And accordingly, they made recommendation to the chancellor. Chancellor made recommendation to government. Government said give this document. And while the matter is pending, now the director rejected my applications. Just kindly see that this is the recommendation.
Yes. Annexure 4.
Annexure 4, page 19.
Yes.
Rationalization of the pay scales. Got it. That is the subject.
Yes.
And I want the second part of particular time earlier. In this connection, this is to bring your kind notice that while one post of program in the computer center at present vacant carries the high scale of pay 7,310,900, the other 3 posts carry lower scale of pay 6,510,500. Even the scale up of these programs are equal. The scale of
Just for a moment. I just want to understand how could there be such a discrimination? How could there be two different
ভুলভাল হয়েছে admit করছেন সেটা ভুল হয়েছে এসে admit করে authority লিখিলে এই authority sanction দিয়ে দরকার
Is it a case of rationalization or is it a case of anomaly? Anomaly
সেটা লিখিছেন what rationalization is there? That may be anomaly, that's not rationalization different.
Anomaly.
That is anomaly.
It could have been rationalization. It could have been an anomaly.
It could have been anomaly. For that there.
So if the scale of pay of these
programs are equal with the scale of pay of the assistant programs in the computer centers, which creates discontentment among the incumbents, and they are pressing hard for upgrading their scale of pay from such and such and such, other than sanction for the first. So this is my authority recommended matter to the chancellors. Then let's kindly see the page annexure 5.
and they call for some documents.
They call for the documents. And again, the register that is
Submitted documents. Well,
yes. Then
with the letter of the chancellor.
the letter of chancellor, let's kindly see. Page 27. 27 and 28 is relevant. The last correspondence is page 32. From the government to the chancellor said you make to the government because government is competent. The government said you produce these records. There's a see page 28. That is very relevant for lots of communities. Page 28, annex,
Yes.
annex 8.
Yes.
That is Uttar University to the Deputy Secretary Chancellors. Reference of say inviting reference to such and such. I am directed to inform you that 2 post of programmers, 1 post of program assistant and 1 post of assistant programmer now exist in the following department of Uttar University, having the scale of pay such and such. Another post of program such and such. Requisite column such and such, though the post carry the same scale of pay. Last para, third para. The designation varies from department to department. The higher scale of pay of the program in computer centers creates discontentment among the other incumbents. So it is felt necessary to maintain uniformity in the scale of pay of the post. The Honorable Chancellor was moved by letter to such and such for reference scale of pay of the aforesaid employees. The Honorable Chancellor was pleased to defer the proposal at present as per the letter note to such and such. The matter may please be placed before the Honorable Chancellor for sympathetic consideration and kind order for revision of scale of pay the aforesaid post from such and such and such. Then page 31. With reference to letter to such and such, inviting reference to letter, I am direct to say that the government hiring department may be moved with adequate justification to obtain the concurrence of finance department for rationalization of the pay scale of the programs and program assistant in the computer center of the university. The proposal of the university, along with the views of the government on the in its score, may be submitted to the office for consideration and approval of the honorable chancellors. Then the government. They sent the matter to the government wrote letters to the registers, reference of pay scale such and such. In inviting a reference to letter such as I am directed to request you to furnish the office order regarding the it's a magila government magila office order. Now the Uttar University see with reference to such an application letter consider authority of the university office chancellor and government department of higher education have been moved to accord necessary approval. However, the matter has not yet been finalized. This is the correspondence made by the assistant registers.
Now to see the final order of the government. Yeah, annex
No, final order has been passed, nothing.
Page 35, what is this?
35. The government said, you'll see. In view of the above factual and legal proposition, if at all, rationalization of the pay program assistance is felt necessary, the vice chancellor with the approval of the chancellor
may take appropriate action as per the provision of law. The government says.
Split with the vice chancellor.
Yes, that's said, you are the competent. Again, the government remitted matter to the vice chancellor and chancellors. Then you see the next page, Utkal University register to the joint secretary chancellor. In view of the above mentioned fact, the matter may please be placed before the honorable chancellor for consideration of rationalization. Again, the registers again recommended the matter to the chancellor. That is page 36, annex 13. These are all corresponding in 9 words. Then the next page, the honorable governor says, this is also relevant. Rationalization substances. I am directed to investigate letter substances, relaxation substances. In the matter of determination scale of pay of the university employee, prior approval of the government is necessary under section 22 of Substances Act. Therefore, you are requested to resubmit the proposal of rationalization of the scale of pay of the programmer, program assistant, and assistant programmer to the government for consideration. Again, the chancellor said to the government. Now, you will see kindly see that is the letter dated 31/12/2011. Now, at this juncture, the assistant registrar passed the orders with reference to a letter on subject cited above and informed that under Wars Bill 2009, the scale of pay attached to the post of program assistant such and such is this. Further rationalization scale of pay does not arise. Now, my grievance is something different.
Your grievance in any case, your grievance is pending with the government.
Pending with the government and chancellor, and there is a correspondent. The self-register recommended.
The government has not finalized it.
Not finalizing. And at this juncture,
But what prompted the register, assistant registrar
yes,
to pass this
that
order?
was these orders. And more particularly, the government sought for some records. Without producing that record, how you can pass these orders? And the person is retirement. The matter is pending since 2012.
Yes. There is a counter. Yes, who is appearing for the university?
I am for the university, my lord. Mr. Ashok Mahmood, let Ashok Mahmood argue this matter. Now he's for that I filed a small counter.
2012.
I am appearing the recently, my lord, this matter. So that
It's all right, all right. I'll grant you only 10 days time to file a counter.
yes, my
10 days, not even 11 days.
no, my lord. Only 10 days.
Shri Ekanath, Land Council appealing for the Utkal University requests for some time to file counter as he has been recently engaged. Let's this matter. आज ये लगे तो बात 26 तारीख को on 26th
25 years on.
26th
25 से
25. मारी advance कर दो.
no 26th more सुविधारम करेंगे on 26th counter affidavit if any be filed in the meantime positively filling which the matter shall be disposed of on available pleadings.
13.
It's Rashi.
Here, my lord, I have challenged the order passed by the opposite party number 2, annexure 10 at page.
Your prayer says annexure 9.
My lord?
Your prayer says that you have challenged annexure 9.
Yes, my lord.
9 is the order of the director.
Yes, order of the director.
You are Managovind Swami.
I am Managovind Swami, director, because I was appointed initially in the high school. Thereafter, my lords, I was not permitted to discharge my duty. This is the third or fourth round litigation before my lord. Ultimately, when the appeal was filed before the director, annexure 9 at page 68, he rejected the appeal. I contacted him last evening. I am told that he has been regularized as a primary school teacher. But the order, since he was in the high school and now he has been regularized, I would like to get the information whether he is
interested to pursue this application.
yes. Now, since he has been regularized by the government service,
Sri
we have
Jayaparath,
to proceed with the case or not.
Sri Jayaparath, Land Senior Counsel requests for an adjournment as he wants to take some instructions from his client. We'll take it up next week then.
Sir, 19th, say, 19th,
We'll this matter next week.
He was in election duty for trading rate.
Just inform, get the information.
Yes, I will get it done.
I don't know, 14.
Yes.
For that, my senior staff leader, last you see the prayer been made to pay the differential gratuity amount of 5 lakhs rupees. That has already been paid since 2013. 2013.
You know, copy, let him take instruction then. So this is an old matter. If Mr. author says that that amount of rupees 5 lakhs has already been paid to you,
Sir,
what's the
yes.
differential amount of gratuity?
the 5 lakhs has already been paid, but without any interest. I am claiming along with the amount statutory interest. That was not paid.
Okay. All right. So let us hear the matter. Because statute provides for interest. Isn't it?
There is we have no actual lacuna because we
That we will decide. Statute. I think section 47, rule 47.
Rule,
Odisha pension rules applies to this case.
yes, sir.
Then 47. You are probably referring to 47, na kete? Interest होता है, है ना? 49.5, हाँ, sorry, 47 बोले कहीं, 49.5.
Interest part to sir,
Interest part.
49.5
ମୁଁ କହୁଛି
7% interest.
এটা কি এমনি কি অপশন যে
Type A minor.
Subsection 3A of section 7.
Okay, the payment of gratuity.
you are referring to payment of gratuity.
Yes.
This is gratuity.
This is gratuity, but if he is to be covered under the pension rule, then it is 49.5.
Where the sanction of payment of gratuity is delayed for more than a year from the date is due under sub-rules 1 or 2 as the case may be, and such delay is attributable to administrative lapses, interest at the rate of 7% per annum for the period beyond 1 year. That is why I asked whether this pension rules applies or the payment of gratuity. I think pension rules will apply.
Payment of gratuity act also applies.
Not signed.
Pension.
That's a central act. That is a central act.
Central act.
Yes. Is there any parametric provision like this? 49.5?
No, 49.5 କିଛି ସେମିତି gratuity act ର ନାହିଁ.
What I found from the prayer in this case, my lord. In fact, initially after the ORSP rule 2008, the benefit was extended in respect of the pensioners from 2009. That's extends NS ceiling limit, my lord. Later on, my lord, few cases were filed, and thereafter referring to a decision of the London Tribunal, the Hon'Ble Committee, my lord, they took up the matter and took a decision that this benefit is to be extended not from 2008, but that is in supersession to the resolution of 2009. They brought out a resolution in the year 2011 that it is to be extended with effect from 1/1/2006. That is the date when the ORSP rule was actually introduced. So the benefit has been extended. It was not extended to the OUT employees. Later on, my lord, as it has been informed, my lord, that it has been extended. So the benefit, what previously it was to be extended from 1/1/2008, now it has been retrospectively applied, my lord, with effect from 1/1/2006 under the Orissa Civil Services Pension Rule, 1992. Basing upon that particular guideline and that retrospective application of that particular guideline, the petitioners claimed this. So I think, my lord, rule 49.5 will come.
Even 49.5 also is in your favor. But then what here they are university employees.
Yes.
University.
They are not directly government employees, they are university employees.
Separate thing, my lord, statute is there also.
No, your statute, there must be an enabling provision making this these provisions of the pension rules applicable to you.
Yes.
There is a provision.
Kindly see 40, section 40, subsection 2 of the OUT Employees Condition of Service Statute 1989.
What does it say, sir?
I have quoted that in paragraph 1.
Paragraph 1.
Paragraph 1 of the read
application. Yes.
Read application.
The employees under the contributory program.
under the contributory provident fund scheme shall be entitled to gratuity, including death gratuity, at the same rate and the subject to the same maximum on the last paid run on completion of 58 years of age or at the time of death before the age of 58 years as admissible under the pension scheme. Kindly see Annexure 8 at page 20.
The government resolution.
20, page 20.
Yes.
Government of Odisha Finance Department resolution. Subject revision of pension, family pension, gratuity and contribution and commutation of pension of.
Yes, this is what Mr. Patnaik was referring to.
This is, yes.
So I think it will be, I think 49
of this is the.
So this pension rules will be applicable to, 49(5) will be applicable to, which also has a provision for statutory interest.
Yes.
In case of administrative, if it is delayed because of administrative lapses
Yes.
beyond a year, then you are entitled to interest. Whether the question is now, the court will have to decide whether there was any delay on the part of the university.
Only
It
one
is
thing, my lord.
it large.
Strictly by going that section 42 of that OUT employees conditions of service statute 1989, it deals with provisions of contributory provident fund scheme. So that is what it is not available in our pension.
No, that is what I had asked you, put a question from the very beginning that they are university employees.
They are university.
So there has to be an
Minority
provision.
Mr. Rath will have.
Sir, please examine this. We'll take it up again. Please examine this. Whether 49(5) will apply or as you are
In any
referring,
case,
because there is a contributory scheme also is there.
in any case, by virtue of Annexure 8, they have paid ultimately the amount. Therefore, the only thing is interest. Interest is very clear. The statute itself says, and 3-4 decisions of the Supreme Court are there with me.
No, but then that is a factual aspect. It has to be decided whether the delay is due to any administrative lapse.
ସେ କଥା କହୁନି ଆଉ ଦିନେ ରଖନ୍ତୁ କିଛି ନାହିଁ.
Sri S.C. Ratha, Learned Counsel appearing for the OUT, files a memo enclosing copies of certain documents showing payment of rupees 5 lakhs to the petitioner towards differential gratuity. Same be kept on record. List this matter on 3rd May. 3rd May, sorry, say dino sorry.
Item number 15.
भूलता मार देगी. Item 15.
State has not filed a counter. Would you like to file a counter or not? Only opposite part of 4 has filed a counter.
Yes, sir. No counter. No, there is a counter. Preliminary counter affidavit.
And the governor, I am the file the counter.
And you have filed the counter. You are the governing body.
People has not paid. But what has the role?
Yes. 2012 matter.
2012 malad. Yes.
The matter of 2012. 12 years have gone by.
Yes.
In Odia, we say go to Jugo of Osan. Isn't it?
For the first time malad it has been listed for lot.
No, that we are sorry. We are sorry. We have been able to take it up earlier.
Several dates are there.
But now I have taken it up means it will not escape.
15 days time.
10 days. 10 days, not a day more, not even 11 days. Sri S.N. Patnaik, Learned AGA, requests for some time to file a counter, which is felt necessary to be perused in view of the averments taken in the writ application. List this matter on 26th April. Counter affidavit, if any, be filed in the meantime, following which the matter shall be disposed of on available pleadings.
Item 16.
List list it will run, start running.
There are only bench thila. Era ଆପଣଙ୍କ ପାଖରେ ଏଟା ପସନ୍ଦ ଅଛି.
ମୁଁ ମୋ କଥା ହିଁ କହୁଥିଲି.
Item 16.
Item 16, yes. Mr. Mahathi,
To get a copy of the OHRC
Yes.
order.
copy of the
OHRC order, basing upon which I have been disengaged.
Malad through a memo malad I am submitting.
that Human Rights Commission order. Yes.
Since I got the opportunity.
You are working as a Asha.
Yes.
My lord.
I got the opportunity to place that OHRC order, my lord. Simultaneously, my lord, I have also enclosed few of the documents which are related to the same and the subsequent actions.
আরে ঝিও এটা কোন বন্ধ হয়েছে এটা it's not showing.
Accordingly, I have been cautioned by the CDMO, but not taken any action. While the matter stood thus, collector basing upon the order of the OHRC has directed to disengage me to the CDMO, and I have been disengaged. So my
No, they directed that initiate necessary departmental action against the erring Asha. Was any departmental proceeding initiated?
no. Your lordship, I see annexed to my lord.
No, what I'm saying, you see, Mr. Patnaik,
Yes, ma'am.
the ADMO FW has concluded in his inquiry that Asha Karmi did not go to the house of the patient at night nor in the morning.
Yes.
She did not contact MO in charge or BPO when Janani Express could have come in time.
Yes, ma'am.
Thus, there was severe negligence in duty.
Yes, ma'am.
Since negligence is Valaswansha awards a compensation of rupees 40,000 in favor of the patient, then the Chief District Medical Officer Kalandi should also initiate necessary departmental action against the erring Asha for her lapse after giving her an opportunity of being heard.
Yes, ma'am.
So whether that was complied with, whether any disciplinary proceeding was initiated against her.
First step of employees, my lord, the OCSCC rule has no application. So a so-called expansion was issued, my lord.
Principles of natural justice have to be followed.
And she also submitted her explanation, refuting the charges. And thereafter, my lord, the matter was closed with a caution not to repeat the same. Thereafter, my lord, another so-called notice was issued. But after receiving the order from the OHRC Commission, thereafter the collector issued a letter to the CDMO under Annex 4, wherein the CDMO was requested to take steps for disengagement of the concerned erring Asha worker immediately, and action taken report may be submitted to my office within a week time, my lord. Thereafter, my lord, this decision was taken. Office of the Chief, Annex 5 and Annex 6.
Yes, suddenly out of the blue, how could the collector say that you have to disengage her? Is it not? Suddenly out of the blue. When in the previous, where is the first show cause? Let us see.
First work was annexed to 1, my lord.
Annex 1.
Yes,
Achha, when is the order passed by the, this is 27/11/2012.
my lord.
So this was in 2013. After issuance of the,
My lord.
after passing of the order of the OHRC. So show cause notice was issued.
My lord.
ଆପଣ ଭିତରେ କାହିଁକି ଶୃଙ୍ଖଳାଗତ କାର୍ଯ୍ୟାନୁଷ୍ଠାନ ଗ୍ରହଣ କରାନଯିବ ତାର କାରଣ ଲିଖିତ ଗଲା. So you submitted a Annex
I have submitted annexed, I have submitted.
2. Then what is Annex 3?
Annexed 3, I have been cautioned and
That was in 26/9/2013.
my lord. Last ଏତଦ୍ୱାରା ଆପଣଙ୍କୁ ଚେତାବନୀ ଦିଆଯାଉଛି ଯେ ଆପଣ ଆପଣ କର୍ମରେ ନିଷ୍ଠା ଦେଖି ଆଶା ଭାବେ ସମସ୍ତ କାର୍ଯ୍ୟ ଦାୟିତ୍ୱ ସମ୍ପାଦନ କରିବେ। 1 ମାସ ମଧ୍ୟରେ ଆପଣ କର୍ମର ଉନ୍ନତି
So
ପରିଲକ୍ଷିତ
the collector almost refused the order. Isn't it?
Yes, ma'am.
So too. Does he have the power? Under exercising which power has he? I mean, overridden the order of the CDMO. That we have to see. OHRC's order was passed earlier in 2012.
Yes, ma'am. There are 2 cases.
2 cases.
Yes, ma'am. I have enclosed both the orders. One is today, my lord, the list of documents.
What is the name of this? Asha?
ଉର୍ମିଳା ସାହୁ।
Urmila sir. My lord, Annex 2, it starts with the Form 9 notice.
Either ଅଛି.
It is the 4th page, my lord. It starts with 4th. Order dated 17/10/2012.
This is, the complainant is Gauranga Maji.
Yes, ma'am. Both the cases, Gaurang Maji.
Gauranga Maji.
In view of
His wife has died. Your Gauranga Maji's wife has died. She demanded rupees 2,000 to attend his pregnant wife. Finding no other way, the petitioner took the help of the local Dhai for relief, but the child died. His wife, however, could survive.
survive.
Right.
Yes, ma'am.
Alleging negligence on the part of the Asha Didi, the petitioner filed this petition. So this was passed on 17/10/2012. Thereafter notice was issued to him, her.
Yes.
And whatever her reply was, the CDMO said that.
Yes, ma'am.
So let us go through the guidelines of the Asha.
That is not applicable.
No, that is, we have to see whether the collector has the power.
Yes.
Who has the power, whether it is the CDMO or the collector.
And my lordship may come to another document. The last word 5 pages, fine. 4 pages.
Annexure?
Annexure 1. These documents are not directed to be produced by me, madam.
No, I know.
We have added those 4 more documents, madam. This is another case during number 1916 of.
Same Asha Karmi.
Yes.
They're showing her negligence in another case.
27/11/2012, Gorangamaji.
Yes. Again, there was still one child.
And my lord, here the direction is, since negligence in providing medical care is admitted in the report, the commission hereby awards a compensation of 40,000 in last year.
So this Gorangamaji is the complainant in both the cases.
Yes, ma'am.
So his wife lost 2 children then.
No.
How?
Good.
Dita in the order. How could there be 2 orders?
Dita case dita order.
Dita in the order. The brown color. She was censured. She was warned.
Yes, ma'am.
Or rather cautioned. Then how could the collector override the order of the CDM? Is there any provision? You find out the Asha guidelines. Last time also somebody
Downloaded a guideline, but no such thing is there from the.
No, whether it has to be authentic, let him produce the.
NRHM, yes, Mr. Vibhuti Tripathi usually used to appear, man, in this case, but he's not appearing in this case. I will contact him and I will get the.
You get the guidelines.
Yes, ma'am.
Guidelines. Heard in part, list this matter on 3rd May. 3rd May. A London State Council shall produce the guidelines governing the engagement and conditions of service of the Asha Karmis or Asha.
These documents may be taken into record.
Leonard approval. Okay.
I have sought a copy of it.
Leonard AG has filed certain documents through a memo after serving copy on the other side. Same be kept on record. We'll continue after recess. Since there are less number of bail matters today, we will continue.
I will prayer. The matter fixed after lunch. 18 may be taken on Monday because they will not be available after lunch.
18 Monday he will be. Monday.
Monday.
The other side is no submit Monday.
Item 3 out pass till Monday.
Item 3.
There
There are 2 different cause of action.
one cause of action. So Monday.
All right. Item 3 be Monday kar de, item 18 Monday kar de.
Item 21 minute. I pattern to make a mention. I am appearing for the opposite point as per the notice. I pray 3 weeks time.
Yes, Mr. Kauder.
3 weeks time. Counter. 3 weeks time. Counter.
Go to me. We have covered up to item
17, 16.
16. Item 17 ki is something?
So 17, I am
Wait.
opposite party man.
Who is the petitioner?
Petitioner is present.
So we'll take it up after recess. We'll call it out. Item 18, Kabala. Item 19,
19.
you are there.
On behalf of Mr. Nanda, your lordship, I have 6 for adjournment.
Who is the petitioner?
I am producing.
Yes. What do you say, Mr. Naik?
Lordship has taken up.
Prayer for adjournment is made on behalf of the opposite party. List this matter on 3rd May.
Not there sorted maybe.
3rd May, interim order to achhi apna favor hai? Achhi? Nahi.
Data case which is 3
Order 9.
More 3 petitioner.
Time, if any application for adjournment is moved on behalf of the petitioner in the court below, the same shall be considered having regard to the date of hearing of this case. All right. Item 20.
I am for the opposite party.
Who's for the petitioner? So let
It be there after.
yes. 21.
My lord.
Mr. Raut.
3 weeks time may be given for.
3 weeks. What, Mr. Martin? 3 weeks.
Yes.
Counter to file 3 weeks.
Coffee day.
See, Maitrijit Mahathir, Learned Counsel for the opposite party, requests for some time to file counter. List this matter on 9th May. Counter affidavit, if any, be filed in the meantime. Is there any interim order?
No.
Subject to result of the data.
It's out of any. Item 22. Roila, 23.
23, you'll also keep it next week.
Yes, no, that,
Contempt.
no. I remember that.
This case is concerned.
I remember that. Come after recess. Come after recess. The application, they should not be kept pending. And you know, no first contempt, second contempt, third contempt, business here. One contempt means contempt.
Yes.
Item number 17.
Opposite party.
Who's for the petitioner?
Petitioner.
Sanjeev Kumar.
What I pray, my lord, similar case filed by the petitioner, that may be tagged with this
No, what is this matter about?
for regulation of service.
Regulation of service. And you are for the petitioner. All right, place this matter next week, will you? All right, place this matter on 3rd May as requested by learned counsel for the petitioner. Along with Kete?
42806/2023.
Yes.
Item number 20.
Item 20.
Petitioner is your wife.
You have appeared, Mr. Raut? This is a transfer filed by the wife?
Yes,
You are the husband? Any chance of settlement?
My lord, I was suggesting my friend for mediation, but he says that no, there is no scope for
There is no scope for mediation.
mediation.
All right.
So, you know,
All right. Place your application. Place your application.
Let the case be transferred to the London Judge Family Court.
Why?
At that place, mediation will be.
No. If you want, I'm not forcing you to for mediation. If you want, I can send it to anywhere you want, anywhere where it is convenient. If you want to meet, if you want actually a amicable settlement.
Because CRP proceeding is still pending, we will refer the.
That is all right. That is all right. But if the matter is settled, then no proceeding will remain pending. All the proceedings will automatically be
One
resolved.
more chance. Maybe
You want to take instruction from him? Okay. All right.
given.
The Raut learned counsel appearing for the husband, opposite party husband, submits that his client is ready for mediation to resolve the dispute amicably. Learned counsel for the petitioner seeks some time to obtain instructions from his client. Place this matter on 26th April. Is there any interim order?
My lord, no interim order.
In the meantime,
he is also not good.
in the meantime, if any application for adjournment is moved on behalf of the petitioner wife in the court below, the same shall be considered, having due regard to the date fixed for hearing of this case. Yes.
Item 22.
In this case,
Challenging the notification issued by the collector Banjam my lord by the annexure 1. This previously for the
Director to take instructions.
Yes.
What is this matter about?
my lord, this is a case wherein the presently, my lord, the applicants are, petitioners are presently working as the Anganwadi workers. In terms of the guideline for the, there is a recruitment rule, my lord, for the recruitment to the post of the Anganwadi supervisor.
Supervisor, yes.
And they claim that they should be accommodated against the 40%
Vacancy.
vacancies of the Anganwadi supervisor through promotion. My lord, for that reason, they appealed before this honorable court. And a batch of cases were heard analogously, and that was the cases were disposed of. Page number 42, my lord.
Page number 42.
Yes, ma'am. And the operative person is at page number 51. on page 10. On page 51.
Yes.
On page 10. There is a direction to consider the case and a decision is to be taken in this regard within a stipulated period, my lord.
In the light of the direction issued in the office of WPC.
State has prepared appeal, my lord. The appeals are pending with the instruction available with me, my lord, over telephonic instruction.
Appeal against this order.
This order, my lord.
The WPC OSC number 50 of 2017.
Yes, ma'am. The batch of cases, my lord.
Is this a batch of? I don't think this is a batch
Yes,
of
ma'am. Pay no 42, my lord. It starts with pay no 42.
42.
Yes, ma'am. 286, 348, 350, 351.
An appeal has been filed. A writ appeal has been filed.
Writ appeal has been filed.
So, wait.
My lord, may I be corrected, my lord? One second. Maybe an inadvertent typographical mistake, but can I take your lordship to the prayer? Here, my lord, orally it has been submitted that he is agreed with the advertisement issued by the Orissa subordinate staff.
You have not challenged it.
And his prayer, without challenging the same, to implement that order of the Honorable Court. So, my lord, a writ with a prayer to implement the order of the Honorable Court when the appeal is pending, the writ is not material. That is my limitation.
So instead of passing any adverse order or any order, in fact, I suggest that we should keep it pending.
Yes,
Till disposal of the requestment. Since your case is based on the order passed by the Contempt bench,
yes,
which is under appeal. So under appeal we decided. Either way, if the order is confirmed, then you can get your order.
In the meantime, notification, appointment of the supervisor.
So have you challenged it?
Yes.
Where have you challenged it, sir?
Yeah, I will challenge.
Fine.
By annexure 1, I have challenged.
Where appointment prayer declare?
Prayer.
With application, you look at your prayer.
1009.
Without challenging it, how can you ask for a stay?
Did to allow the petition and issue notice to the opposite party. After that, pass necessary orders of the deemed fit and proper as per order of this honorable court dated to it in the test. And pass any order as deemed fit and proper.
No. You have to specifically challenge it.
Challenge by the annexure 1 that notification.
Sir, you have not challenged it. You have
Intention of the honorable court.
No.
My lord, the direction, this honorable court has given direction to the authority. In the pendency of the order, if my lord order is saying that this appeal is pending, how the notification is implemented by this authority?
That
order of the honorable court. How the authority has notified it?
So you challenge the notification.
I have challenged it.
Where have you challenged it?
My lord, this is the
challenge.
Challenging the notification. I've had annexure.
You should specifically ask for quashment of that notification.
Yes.
Where is it?
And stay petition, I have also mentioned.
Stay is a part of the writ application. It arises out of the writ application. If you have not challenged the notification in the prayer,
Yes.
in the main writ application, you have not prayed for quashment of the notification, and you want to stay.
Pass any order or
Any other order? What are you saying, man? What are you saying?
Another.
It has to be a specific challenge.
My lord, the challenge is also the notification.
No, it is not there. It is not there in the prayer. I refuse to accept it. As simple as that.
Amendment.
You may amend it, it is up to you. Leave this matter 1 week after.
Yes.
As the learned counsel for the petitioner wants to file an application for amendment.
23.
Yes, Mr. Joshi.
Yes.
Compliance affidavit has been filed.
Yes. In fact, it was complied and rejected.
Rejected, can drop now. Sorry, where is that affidavit?
It was 6/4/2024.
Has it been filed?
On 6/4/2024.
The compliance affidavit has been filed. Where is that? Declare. Yeah, sir,
They did not form part of the record.
Sir, I had seen it.
Sir,
It's not there in the physical record.
noting it.
Good. The compliance affidavit has been filed by the sub-collector Bhavani Patna, stating therein that the representation, that a decision has been taken on the representation submitted by the petitioner by him as per order dated 4/7/2022. No, sorry, as per order date.
26/2020.
6, no, 4/7/2022, you're right, 4/7/2022, pursuant to the direction of this court,
Dated 20.
26/2022, passed in WPC number 14828 of 2022. In such view of the matter, the contempt application is dropped. Yes.
Item number 25.
Permitted to withdraw.
Item 25 to 24.
No, 24 to withdraw, right? 25. Permitted to be made correction be made accordingly.
Item number 26.
Item 26.
Finally, this case for extension of interim bail,
Yes.
the petitioner met with an accident and he was severely injured, for which time may be extended.
It has already been extended once.
Yes, madam.
I don't know, 9/11/23 interim bail was
Extended. He was not recovered, that's why. And in the meantime, the victim was examined. He has not stated.
He is an interim bail at that time victim was examined.
See, bedridden.
No, I will not allow. I will not allow. Bedridden ଅଛି କାଇଁ document କାଇଁ?
ଦେଇଛି ଆରଥରକ ଦେଇଥିଲି accident ର ସେଟା ଅଛି ଏଇଥିରେ ଦେଇଛି ଗୋଟେ ଡକ୍ୟୁମେଣ୍ଟ ମେଡିସିନ ଗୁଡା ଦେଇଛି 2 months
ହବନି ନା
ଲାଷ୍ଟ ଚାନ୍ସ ଦିଅନ୍ତୁ
ବହୁତ ଦିଆଯାଇଛି ଏଥିରେ ବହୁତ ଦିଆଯାଇଛି
ଲାଷ୍ଟ ଚାନ୍ସ ଦିଅନ୍ତୁ ମୁଁ ସେଇ ଯୋଗୁଁ ଲାଷ୍ଟ ଚାନ୍ସ
no to be fair to the court don't press this application please don't press this application I am going to reject it it's better you don't press it
1 month as last chance
no still if you I will reject it considering these submissions
last chance
on the grounds cited for extension of the period of interim bail
going to be expired on 15th May some more days your lordship
I am not inclined to grant any further indulgence to the petitioner the IA stands rejected yes
for some days
no sir
not 2 weeks दियंतु as last chance
no आपको being such a senior counsel now I have said that you come fair to the court I am saying that don't press this application that is why I have rejected it yes
not press one
Item 27.
reject person not press one no dieta ହେଇପାରିବନି you cannot have the cake and eat it too either have the cake or eat ଦିଟା ଭିତରୁ ଗୋଟେ both ହେଇପାରିବନି yes item 27
Item 27.
not press
permitted to withdraw not press କରିଦିଅନ୍ତୁ ଏଇଟା not press
Madam, on behalf of Amul Ratna Panda,
yes
I have filed this IA for modification and extension of time.
first time
This is
This has come for the
first time
first time?
modification, my lord.
what modification do you
Modification is that after passing the lordships are done, my lord. On dated 13/10/2023, the present petition on dated 19/10/2023 filed an advance petition along with the certified copy of the order, my lord, in the court below, my lord. But thereafter, the learned magistrate called upon for the injury report. But the IO does not produce the injury report, my lord. So for which the present petitioner is unable to.
you want 2 weeks further time
Further times and the injury as per the instruction I have taken, the injury is grievous in nature in the hand, but not on the vital part of the body, my lord. So this is
all right, the last sentence all right will do the last sentence in paragraph number 5 of order dated 13/10/2023 be deleted 2 weeks further time is allowed for the petitioner to surrender
my lord, obliged.
Item 28.
May I please your lordship?
yes
My lord, I have filed the I for extension of time.
is it for the first time
Yes, my lord.
all right 2 weeks time
Obliged.
Item number 29.
item 29 none appears business matter next week
Item number 30.
Item 30, I am applying through DC, my lord.
yes
My lord, my lord, for extension of time, 3 weeks extension may be granted. And then meantime, the IO and IIC GoPOPS may be directed to produce the injury report. Because my lord, in pursuance of your lordship's order, I have the petitioner also filed a petition before the trial court for bail, but the IO or IIC is not submitting the injury report from the capital hospital, and the London trial court has sought for an explanation for him through the concerned SP.
So time and again, and they are not submitting the injury report. So my humble prayer is the IIC GoPo PS may be directed to file the injury report, and 3 weeks time may be granted.
Weeks further time is allowed to the petitioner to surrender in terms of order date so and so. Further, the court below shall ensure that the IO submits the injury report as early as possible. Yes.
Obligement.
Sure. Yeah, I don't know. Is there any noting? 9 minutes. The Chief Justice has marked it to me. No, इसकी मिश्र election थी. नहीं, but it is written इसके मिश्र. There's a slight doubt whether the matter has been actually assigned to me or Justice S.K. Mishra. Because I don't write S.K. Mishra, I write my full name or S. Mishra. The Chief Justice has endorsed it to S.K. Mishra. There is another judge, S.K. Mishra. Justice Sanjay Kumar Mishra.
No, what happened, my lord? An earlier folder application was literally also.
I know.
In fact, on 16th of February, before the learned judge before whom it came, my learned friend pointed out that perhaps there is some practice direction that it must come back before your lordships. It's in that context that this.
No, we have a standing order based on the judgment of the Supreme Court that whoever has heard any jail application or any matter arising out of the same FIR,
yes,
the matter should come to me.
Correct.
Come to the same judge.
Correct.
But here there's a technical. Call the DR. Call the deputy registrar. Okay. Okay. 22-3. No, I have no objection in hearing. Yes. No, he has referred to it had gone to Mr. Sivasankar, Mr. Justice Sivasankar, Mr. He says the court bench of this court has disposed of the said case by its order judgment dated 2/9/2023. The earlier application I had. Okay, just call the DR. Call the DR. Let us know. I think it could be wrong. Normally, in some of the matters in which have been assigned to me, the Chief Justice writes the full name.
I see.
But here it is written as Kimse. That is what is causing the confusion. So let the DR come. We'll find out. Anyway, what is this matter about?
This is, if I may say so, in a sense, a second round. Because when I had come on the earlier occasion,
you have come for quashment.
Yes. No, we are not at a complaint stage, because what happened in the earlier round, we had come at the stage of ECIR.
Yes.
And my learned friend raised an objection that a 482 will not be maintainable against an ECR, citing a division bench judgment of the Madras High Court. The lordships were pleased to accept, my lord, that contention, and my lord dismissed on the sole ground, my lord, that it is not maintainable, and expressly observed that your lordship is not going into the merits of the matter, expressly. Because we carried that matter in SLP. Now, while the SLP was pending, my lords, on 30th or 31st of October 2023, that is after your lordship's order, they filed a complaint under the PMLA.
Okay.
So now we're at a complaint stage. So all that technical objection about ECR being administrative, I'm not entitled to a copy, all that goes. So, my lords, in those circumstances, we brought it to the notice of the Honorable Supreme Court, said that in the meanwhile, this complaint has come, so therefore we are withdrawing, and that chapter in a sense closed. So therefore, my lords, we are before your lordships now in this proceeding, seeking specifically now, my lords, the quality of the complaint. No doubt, my lords, my friend has raised objection on maintainability of this also, my lords, I will deal with that. But that is where we are at today, my lord.
No, but can you not file an application for discharge before the court?
I could, my lords, in due course. I could perhaps in due course, my lord. The thing in this case is, my lord, my discharge against the predicate offense, that proceeding is pending in the Honorable Supreme Court. Because, and there is an order there of no coercive measures, and what those consequences are, I will come to, my lord. So that is at that stage. At this stage, my lord, the complaint has been filed, we have been summoned, my lord, and at that we have come before your lordships at that stage right now, my lord.
No, what is the objection to maintainability of Mr. Agarwal?
My lord.
Only what is your objection to maintainability so that he can address? you are raising the question of maintainability in this application also.
Not, it's a maintainable. Question is whether at this stage your lordship can exercise power under 482 or not.
That's all, that's whether I make out a case or not.
Whether he can make out a case, it depends. So the maintainability aspect is not there.
At some stage, I think on the first occasion when predecessor objection that it is.
I accepted it. I said that following
In this petition, when it came.
following Bijamadal basically, not yes, but Bijamadal. They have made a distinction between ECIR and
IR, correct.
So where it has been held that it's basically an administrative action.
Correct.
Isn't it?
And therefore, in light of also what the Madras High Court said that therefore it's not an order under the code, therefore 482 will not lie.
So I have also relied upon another judgment probably. I don't know. I've forgotten about it. Where I've said that it has to be a criminal, it has to be criminal in nature for us.
Yes, that is what I cited that Madras High Court division bench.
No, I have also probably cited a judgment. I've forgotten. I'm not in 482.
I think possibly your lordship is before State of West Bengal versus
Yes.
Kumar Rana.
Yes.
Your lordship is right, my lord. And then your lordship is similar view taken of Raj Kocha.
Yes. My lordship referred three judgments. Haryana Bhajanlal, State of and Rabindra.
Here may go away by the memory. Now, so this is basically the objection with regard to maintainability, and that has become infructuous.
That has become infructuous, and your lordships in paragraph in the last paragraph of your lordship's order specifically have observed that I am not going into the merits of the matter. So your lordship did not
just refer to that particular paragraph.
Yes, kindly have notes. It's annexed 3. At page A23 at page 1064.
1064, yes.
It starts, my lord, earlier, but the operative para 12 is at 1064.
Yes, I've got it.
Para 12, conclusion. From the conspectus of the analysis made herein before, this court is of the considered view that the act of registration of ECIR against the petitioner and the investigation inquiry said to be in progress on such basis are not amenable to judicial review by this court in exercise of its inherent power under 482. Further, the present motion, which is at stage when the investigation inquiry initiated on the basis of the ECIR registered against the petitioner, has not culminated in lodging of a complaint under section 44.
Then it had not culminated.
It had not. Is premature. In view of such finding, the contentions raised by the parties touching upon the merits of the case are not required to be gone. And that complaint, my lord, was filed on 31/10/2023 after the lordship's last order.
Which is Annex 1.
Yes.
Yes.
Yes. No, I still have this question for you. Why have you rushed to the court at this stage? Why not wait till the stage of filing an application for discharge comes? I'm not stopping you from arguing.
No,
why not? Why not?
I mean, that could be an option, my lord.
Because you're losing your forum. I don't know.
It could be an option, my lord. But it's a very peculiar case over here, my lord. Just 3 or 4 dates, and I'll say why I'm saying it's peculiar.
Yes, please.
Their case taken against me as it is on the face of it, because at this stage the jurisdiction is circumscribed. That in the predicate offense, the period for which I am charged for illegal mining, etc., is 31/7/1990 to 31/7/2009. That is the period, my lord. In that charge, and that FIR, my lord, was lodged on 18th of November 2009. That culminated in a charge sheet on 26th of March 2013. The ECIR in this proceeding, my lord, in this case, starts only 8 years later on 19th of March 21, culminating in the complaint in 23. That is one facet. Now, as your lordships have seen, the period is up till 2009. Two interesting features, my lord. And what is the only scheduled offense as far as I am concerned, as your lordships are aware, for me to be caught in proceeds of crime, I must be a offense in the schedule. Although under the original charge sheet, there are various other provisions, Lord Mines Minerals Act, Forest Conservation Act, etc. For the purposes of PMLA, there are only 2 offenses that are relevant in my case. One is 120B of IPC, and the other is section 13 of the Prevention of 13(2) read with 13(1)D of the Prevention of Corruption Act.
120B, my lords, is added in the schedule only in 2009. Section 13 of the Prevention of Corruption Act, to the extent we have been able to see, my learned friend can correct me, my lord, comes into Part A only in 2013.
Okay.
There is a Part A and a Part B. Part B has a threshold. Part A has no threshold. Prevention of Corruption Act was originally in Part B. And even in the original Part B, Section 13 was not there. It is only in the 2013 amendment that it shifts from B to A and Section 13 is introduced.
So what is the ramification?
Now, what is equitable? The obvious question that was the contention of the other side will be, it makes no difference. Because these are offenses that were committed earlier, they were always offenses. But the law is clear even from Vijay Madan Lal as interpreted subsequently by High Courts.
Let me just complete. Yes, Mr. Nayak, this matter has been marked, apparently marked to me, but the endorsement by the Chief Justice is Justice S.K. Mishra. So you are sure it is assigned to me? All, thank you. Thank you. Yes. So this little legal had to be taken care of.
Of course, your lordships have to be satisfied.
Because this is not in my assignment, why should I?
That's what we were told, yes. So it was 2013 for the first time it comes.
PMLA Act about it.
Unfortunately, the Blair Act doesn't give us much guidance because it only tells us 18 and 9 recent amendments.
But we can find the gazette notifications.
Yes, I will place them later on if necessary, my lord, the tracing of the sequence. Now, no doubt they will say these were always offenses. 120B was an offense. The PC Act was an offense.
Was it a schedule offense?
And what Vijay Madan Lal says, and also understood by subsequent high courts, what is relevant is the offense of money laundering. There must be an offense of money laundering. Now, if according to you, the offense is for the period up till 31/7/09, where is the offense? How can you trace this money laundering back to 1990? It was not an offense in 1990.
Mr. Nair, can I ask you to pause for a moment?
Yes, Lord.
Just this is academic.
Of course.
When you say whether an offense under money laundering is made out or not, what is it? It's basically laundering of the proceeds of crime.
Correct, Lord.
And by committing some offenses which have been mentioned in the schedule.
Correct, Lord.
So, when you say, it sounds a little bit, confusing for me at least, that when you say that those offenses were not part of the schedule or they were part of the schedule in a different form, so this offense could not have been.
No, I'm coming to that, Lord. Because what is very curious in this case, in the charge sheet in the predicate offense, they say loss cost to exchequer 130 crores. What is there in the complaint? Verbatim picked up those figures and said that this is the proceeds of crime. Now, my lord, admittedly, in that charge sheet, the dates are disparate, spreading over 20 years, different. There are 4 categories of sales tax, illegal mining, etc., etc. Those 4 heads I'll show. They all pertain to a prior period. Where, no, notwithstanding the fact, 482, we must read the complaint, etc., etc. But the foundational fact they still have to show. Vijay Madan Lal Chaudhary says the foundational facts have to be there. Now, can you show from a reading of the complaint that there are foundational facts that this offense of money laundering, where you have just bodily copy-pasted that figure from an old chart sheet and pasted it into the complaint, that those are proceeds of crime? Relatable to which period? And one nuance, my lord, if I may say so, those specifically raised in para 65 of Vijay Madan Lal, that what is the extent of retrospectivity of PMLA? Like, and mine is a peculiar case like that. Not answered. That point, that contention is expressly not answered in Vijay Madan Lal. As to what will happen in these peculiar cases where perhaps the offenses are earlier and now you are proceeding later. And mine is an even more peculiar case, apart from the fact that according to even the loss or the proceeds, etc., for a prior period, even the schedule comes in later. There are, of course, judgments to suggest, my lord, that merely because it's added in the schedule later may not be of significance. May not. Because what is relevant is the date on which the offense of money laundering has taken place.
So the Article 20 argument is not there.
It is there, raised, but to my understanding of the, it is dealt with, but not it dealt with very different.
That is post facto law, that operation.
That was for another reason, my lord. That discussion in the judgment is primarily in the context of dealing with the Supreme Court's earlier judgment in Nikesh Shah. Because in Nikesh Shah, two judges said that the provision regarding bail, etc., is hit by Article 21. Then they amended the Act in 2019. Now, when they amended the Act, there was a whole discussion in the judgment about Prithvi Cotton Mills and all that line of judgments, whether it's a validation, you remove the defect, etc., etc., and they uphold the amended provision. So the context of the Article 20 and the validation judgment, to my understanding of Vijay Madan Lal, is slightly different. This contention, and I'll show that it's quite precisely raised and recorded in the judgment, doesn't appear to me, my lords, to have been answered as to what will you do in a situation like this. And that is why, my lords, I say it goes absolutely to the root of the matter. Quite apart from the fact, my lord, the second peculiar fact in my case is, which your lordships perhaps recall, is that in the first round, in that predicate offense round, Supreme Court said no coercive measures. What is the consequence of that? Because recently, my lords, of course, it's an interim order. The Delhi High Court has taken the view that there was a customs proceeding. The gentleman got exonerated in the customs proceeding. But there was a customs prosecution which was stayed. Now, on the basis of the stay of the customs prosecution, there was the Delhi High Court granted a stay of the ECIR itself. Of course, that was a 226. So this technicality of 482 did not arise. But I'm just giving a facet. At least I have today a live example where, based on an earlier order of stay, a subsequent PMLA proceeding has been halted. Second judgment, my lords, which I want to show your lordships, of the Telangana High Court of his Lord Justice Bhuyan, as he then was, that he says he received Vijay Madan Lal Chaudhary. And no doubt, my lords, though they may be separate offences, standalone, etc., etc., Vijay Madan Lal is very clear that if the predicate offence goes, this will automatically fall. That is the upshot of Vijay Madan Lal. Because though they may be independent standalone offences, but very clearly held that if the predicate offence gets paused or the gentleman gets acquitted, then the PMLA.
How does it help you?
This is a slightly different aspect. What the court finally says is that the PMLA proceeding, there should be, the words used are, there should be a pause. And in that case, beloved, of course, there they went to the PMLA special court and said, you please hold back the PMLA proceedings till the predicate offence is concluded. The trial court, special court rejected it. It came up to the High Court. The High Court said they should, although they are to be tried by the same court under section 44, etc., etc., there should be a pause by the PM. It's an incidental subsidiary argument of mine, lords. No doubt that SLP is pending. There is no stay, my lord. But that's just an indication of, my lords, what is the judicial or the trend of the judicial view, that what happens when there are two proceedings going on and there is some kind of interim protection that is granted in the main case. How should this case be dealt with? Broadly, those are the 3 or 4 areas, my lord, that I wish to address this court.
I think we should begin with the complaint.
Yes.
In order to understand the.
Yes. That complaint is A1, my lords, page 57.
Yes. I think we can come to page 60 probably, the brief summary of.
Yes, my lord. Also, one more facet, my lord, in the, just as a background, in the predicate offence, there are 15 accused. Because for the purpose of, because there's a PC Act offence, so the first 14 accused are government officials.
Public servants.
Public servants. I am the 15th accused. Of course, in the PMLA proceeding, nothing is taken against them. I am the only person, my lord, against whom the proceedings have.
They must be mining officials.
Mining department officials, my lord. Because only I am pointing out, because even this complaint repeatedly talks about connivance. Connivance means 120B. But who have done the 120B is not there. That's all. Para 2, my lord. At page 60.
Yes.
PMLA Act 2002 is an act to prevent money laundering and to provide for confiscation of property derived or obtained directly or indirectly from or involved in any process or activity connected to proceeds of crime, including its concealment, possession, acquisition or use, and projecting or claiming it as untainted property. Since 120B of IPC and section 13 of PC Act as per FIR so and so dated 18/11/2009 and the charge sheet filed therein 26/3/2013 of Vigilance Cell are scheduled offences under para 1 and 8 respectively of part A of the schedule as defined under section 21Y of the PMLA. Investigation under 21NA of PMLA for the offence of money laundering was initiated after recording brief facts of scheduled offences in ECIR bearing so and so against the accused persons for alleged commission of offences under 3 and 4. So it proceeds on that assumption. That the FIR number 51 dated 18/11/2009 of Balasore Vigilance and the subsequent charge sheet dated 26/3/2013 filed by Vigilance Cuttack before the Honorable Court of the Special Vigilance Judge Kionjar revealed that there were certain illegalities and violations under section 13(2) read with 13(1)(d) of the PC Act, section 120B 379 of IPC, section 3 of FC Act, section 21(1) of MMDR Act, and section 58 of Mineral Concession and Development Rules, which had been allegedly committed by so-and-so at BD Patnaik Kala Parbat Iron Ore Mines, Joda Kionjar, in conspiracy with the mining officials and officials of Steels and Mines Department, Government of Odisha. That mining lease for Kala Parbat located at Thakurani Reserve Forest and Village so-and-so at Joda under Champua subdivision of district Kionjar was initially granted for a period of, please note this, 30 years from 30th July 59 to 31st July 89 to Shri Bansidhar Patnaik, resident of so-and-so. Bansidhar Patnaik, the mining lease holder, since expired, had applied for first renewal of mining lease before 31/7/88, which was never granted to the applicant. Regarding the deeming provision of extension, as per the prevailing law in force, Rule 24(6) of the Mineral Concession Rules, the period of lease should be deemed to have been extended for a period of 1 year. This is a point of contention, but I'll come to it later. Even then, the maximum period of extension of mining lease could be deemed to be extended only up to 31/7/1990 and not beyond that in any circumstances whatsoever. Hence, the mining operation by so-and-so after the grace period of 1 year of expiry of the mining, that is 31/7/1990, without renewal of mining lease and due approval of MOEF, Government of India, was illegal contrary to statute. The working permissions granted in favor of Messrs. BD Patnaik by government officers from time to time from 26/12/1992 to 26/12/94 and also in contravention to the provisions of the then prevailing law. That even these working permissions, though wholly illegal, got expired on 26/12/94. Thereafter, neither working permission whatsoever was granted, nor the renewal of mining lease was ever done by the government. The mining lease holder, Shri so-and-so, expired on 5/11/95. Statutory permissions under Forest Conservation Act were not received. As per Rule 25A of the Mineral Concession Rules, the application for renewal of mining lease could be made only by his legal representative in the death of the mining leaseholder. Thus, after the death of Bansidhar Patnaik, application of RML would have been submitted only by his legal heir, but the mining authorities had not obtained any records, nor took any decisions regarding legal heir of Bansidhar Patnaik, the original lessee. Rather, there was documentary evidence that the district judge in judgment dated so-and-so held that the will dated 1/3/86 claimed to have been executed by Bansidhar Patnaik had been forged and fabricated. The provisions of deemed renewal to renewal of mining lease was statutorily provided by state government via Rule 24A6, which was inserted only in 27/9/94. Thus, the new provision of deemed extension under 24A6 of MC rule was not applicable for the application of RML made prior to 27/9/94 and not at all in favor of late Shri Bansidhar Patnaik, whose mining lease already expired on 31/7/89. After the death of mining lease holder on 5/11/95 and in the absence of any documents on the identity of actual legal heirs, Deputy Director Mines should have stopped mining operation after 5/11/95 on this additional ground, which was also not done. Records also indicate that G.N. Patnaik, one of the sons of late Bansidhar Patnaik, in conspiracy with others, was allowed to carry out the illegal mining operation. That Shri Bansidhar Patnaik had applied for a renewal of mining lease for 10 years for the period from 31/7/89 to 31/7/99, which was pending for approval. Shri Patnaik, who was not G.N. Patnaik, who was not a legal authorized representative for this mining lease, submitted a letter to the Joint Secretary Steel and Mines on 6/9/96, requesting to grant a renewal of mining lease for 20 years. Shri Jitendra Patnaik has not submitted the prescribed application for RML for the later period of 10 years from 31/7/99 to 31/7/2009. Thus, legally, there was no application for RML for the period from 31/7/99 to 31/7/2009, as per the mandatory provisions, as Shri J.N. Patnaik was not an authorized legal heir to apply for the same. Thus, the mining operation carried out during the period from 31/7/99 to 31/7/2009 was without any RML application and was totally illegal, unauthorized, in addition to illegal mining carried out for the period 89 to 99, for which also there was no renewal of mining lease by county authorities. That, now this is not where it proceeds, that as mentioned above, it is found that the mining operation carried out in the above iron ore mine for the period from 31/7/1990, even if a grace period of 1 year is considered, to 31/7/2009 by or on behalf of the ML holder was wholly illegal. The government officers mentioned as accused in the charge sheet filed by Vigilance Department in connivance with J.N. Patnaik and others had allowed illegal mining production and dispatch of mined iron ores without existence of any RML, without clearance from MOEF, Government of India, for the relevant period, and extended undue favor to the mining leaseholder to derive pecuniary advantage by manipulations and fabrications of record. Shri J.N. Patnaik, son of so-and-so, in connivance with the government officers, continued extraction of iron ore even after expiry of the lease period granted to his father, and derived and obtained thereby an undue pecuniary advantage, please note this, of 130 crores so-and-so in the period from 1990 to 2009, and made a corresponding wrongful loss to the government exchequer. This, I will show your lordships, is identically taken from the charge sheet. It is further revealed during investigation conducted under PMLA that this amount was further utilized and layered by the accused persons to accumulate thereby further monetary gains to him. Accordingly, the proceeds of crime as defined under 2(1)(u) is much larger than the original ascertained loss of 130, since Jitendranath Patnaik continued to utilize and enjoy the derived proceeds of crime for all those years beyond 31/7/2009. Further investigation is still under progress. The above mentioned FIR disclosed commission of offence punishable under 120B, etc., etc., are offences under Para 1 and Para 8 of Part A of Schedule to the PMLA defined under so-and-so, and subsequently ECIR was initiated. Then 3.8 is definition of proceeds of crime. And at the top of 66, my lord, accordingly, in order to identify such proceeds of crime generated as a result of the commission of the above explained criminal activities, investigation under provisions of PMLA was initiated. Now, that is what we are supposed to do, my lord. Look, to ascertain, my lord, what are the proceeds of crime generated? Then, my lord, there is a reference to all the search and seizures. The lordship may just note, my lord, that at Para 67, just above page 67, just above Para 6, that they have, lords, attached money as well as fixed deposits way in excess, my lords, of the alleged proceeds of crime. 133 crores are fixed deposits, 70 lakhs is cash. All that is not, of course, subject to a separate adjudication, because that has been confirmed and we are before the appellate authority, my lord. Whatever, that will take its own course, my lord. Then, but the next few pages, I need not trouble your lordships, because that is all the details of the seizures that they have and the details of the fixed deposits, etc. Now, Lord, kindly come to and only one interesting feature, my lords, at page 74, just above Para 8.1.
Yes.
Table D.
Yes.
I am number 1, my lord. 2, 3, 4, and 5 are other family members who are part of the partnership firm. This is a reconstituted partnership firm. Though I believe, my lords, they say, my lord, that summons have been issued and statements have been taken. But to my knowledge, my lord, no other proceeding has been taken against them. There is no attachment order, my lords. I am the sole target of their affections as far as it is concerned right now, my lord. Now, my lord, the statements are reproduced. I am not troubling your lordship with that. Kindly have page 80, Para 9.
Yes.
Brief summary of results of investigation. The complainant submits that several evidences were collected during the course of investigation under PMLA which satisfy the conditions as stipulated under Section 3 read with 2(1)(u) of the PMLA in the instant case. That the investigation conducted under the provisions of PMLA clearly establishes that Shri J.N. Patnaik, partner in B.D. Patnaik, had committed the offence of money laundering in relation to proceeds of crime derived out of the commission of criminal activities related to illegal mining in connivance with the government officials during the period from 31/7/1990 to 31/7/2009 at Kala Parbat so and so. It is revealed from the investigation that Shri Patnaik had been looking after the mining operations at Kala Parbat without having any valid mining lease and clearances from MOEF Government of India. Initial lease period was from 31/7/59 to 31/7/89 in the name of his father. The leaseholder continued mining operations for the further period of 1 year since expiry of the mine.
Because the same thing has been.
Very well, Lord. Now just come just above that table, my lord.
Yes.
Just 4 lines above that table, but he in connivance.
Yes.
But he in connivance with the government officers had carried out mining operations in a wholly illegal manner during the period so and so, and derived thereby a total pecuniary gain of 130/39 so and so, and consequent loss to government exchequer as follows. And this table is given. Please just make a note. I can show it also, my lord. This is the exact same table at page 581 in the paper book. That is part of the charge sheet. These entire figures and heads are bodily lifted from the charge sheet. So there is no investigation or linking as to what are the proceeds of crime. Because if you are saying some activity has taken place over 20 years, how does that suddenly magically all of it become proceeds of crime in 2009 or 2013 or 2021? Because what the act itself is in 2005. The offence of money laundering itself is only in 2005.
2002, I think. But
comes into force on 1st July 2005.
Yes.
So there is no offence till 1st July 2005 at all. Coupled with the fact, as I pointed out, 120B comes in 2009, PC Act gets added only in 2000. Section
But you will have to, I think, I'll ask you to address on that point of retrospectivity.
Yes.
As decided in that Vijay Madan Lal.
Yes, yes.
Or even otherwise.
Correct.
Because I knew that this point will obviously come.
Yes.
From your opening arguments, I knew that this point will definitely come. So you'll have to address the question.
Because and unlike many of the other cases that are reported notes, this is the one that at least factually is a little different because the facts are very stark in this case. The period is much prior.
So you are saying that there has been no independent investigation insofar as PMLA Act is concerned.
There is one paragraph I will show
that predicate offence charge sheet has been lifted bodily and placed here. This is your submission.
And you have to show what are the proceeds of crime. There have to be foundational facts. If the law is not that whatever the FIR says, I will copy paste and make it the PMLA complaint notes, then what is the need? Then why is it a standalone offence? Then you say it's an offence that you deemed to commit an offence. It's not a deeming provision. It's not a deemed offence. There has to be a linking to with the original offending act to a proceeds of crime. Which of the 130 crores in 2009 is the proceeds of crime? Because I have to take 130 crores against me for the time being. I'll proceed on that basis. These are proceeds that spread over 20 years. It can't be more that ipso facto becomes proceeds of crime. Now let's page 82.
82, yes.
Para 9.3. It was already revealed during investigation under PMLA that aforesaid loss of 130 caused to government exchequer till 31/7/2009 was further utilized and layered by the accused persons to accumulate additional monetary gains to themselves, as J.N. Patnaik had utilized such POC into his various business activities after siphoning off the same into his bank accounts. And I cooperated 8 or 9 times summoned. Repeatedly, my statement is recorded. So it's not that I evaded or I've not been part of the investigative process. It is revealed that Patnaik Minerals Limited, wherein Jitendra Patnaik has been a director, has taken the money in form of loans and advances from B.D. Patnaik, which were further utilized by Patnaik Minerals into his business activities. Sri J.N. Patnaik has taken these proceeds into his bank account in form of director's remuneration and dividends, which have been further layered by creating fixed deposits. Sri J.N. Patnaik during this period enriched himself by siphoning off the POC to the tune of 130. So what does it mean? You are assuming that the 130 is POC in its entirety. The same is also illustrated after the analysis of the audited accounts and reports for the period 93 to 2010, which were duly seized under section 17 on 11/5/21 from the premises of so and so. To cite one such instance, it is revealed that Patnaik had received 1 crore 88 lakhs from the business profits of the mining activities at Kala Parbat during the period from 93 to 2010. During the period under investigation under PMLA, J.N. Patnaik had never revealed about such proceeds which he had received from B.D. Patnaik, also did not divulge anything about utilization of such proceeds. Further, the profits of mining activities at Kala Parbat by Patnaik have been further diverted to various other entities related to Patnaik. To cite one such instance, it is revealed that one company, Patnaik Minerals, wherein Shri Patnaik has been a director, received 14 lakhs in 2005 and 6 being a sundry debtor. Also, loans and advances have been extended to Patnaik by B.D. Patnaik. J.N. Patnaik never furnished such details of amounts received by Patnaik Minerals and regarding further utilization of these proceeds. Transfer of such proceeds in the aforesaid manner is nothing but layering of POC. The aforesaid total gain by Patnaik to the tune of 133,8704,838 along with interest accrued thereupon is nothing but the proceeds of crime in terms of section 21U, and the same represents the property derived or obtained directly or indirectly by him as a result of criminal activity relating to the scheduled offense, or the value of any such property which was further utilized by Patnaik into various other business activities. He continued to enjoy those proceeds of crime till date, which have been further proliferated through various kinds of their subsequent layering. It has been seen from the bank accounts that Patnaik had utilized proceeds of crime received from B.D. Patnaik by investing it for his other business activities related to mining and enriched himself. Profits which had already received loans and advances from B.D. Patnaik out of POC. Proceeds of crime as defined under 21U were further proliferated under J.N. Patnaik, continued to utilize and enjoy it all these years beyond 31/7/2009, wherein further investigation is under progress. The said pecuniary gain used by him for various other purposes and laundered in terms of section 3 of the PMLA. Patnaik had been continuously enjoying the proceeds of crime by its possession, acquisition, use, and projecting it as untainted money. During the course of investigation, Patnaik concealed the fact he kept applying for working permission for mining at the said mine to the concerned state authorities without even revealing his authority to do so. That application for renewal for the period from 89 to 99 submitted by Patnaik was pending approval of MOEF, and in the meantime, working permission was granted for the period 92 to 94 for mining operation in violation of the prevailing law. Now, then that's again a repetition of the earlier allegations that I have already read out, my lord.
These are all repetitions.
These are all repetitions, my lord. And your lordships will find repeatedly, again at 86 at the bottom, para 10.1, last 4 lines of 86, the POC identified as of now is tune of 130, which is the same exact figure. And if the lordship sees now at 87 bottom specific role of accused, then it's summarized in a tabular form at 88, 89 and projected it as untainted. Everywhere it is such POC. The such POC being that 130 crores. He allegedly committed criminal activities explained in the FR and respective final report, thereby generated proceeds of crime as defined under 21U. But there is no reference to when these proceeds of crime are generated, because the assumption and the, if I may say so, the presumption is that all that transpired between 1990 to 2009 qualify as proceeds of crime automatically. And the fact that I have paid royalty for all this mining, the fact that all my income, my lords, is disclosed and I paid income tax on all these for all these years for whatever income I derived, my lord, all that, my lords, is brushed aside, saying, "Oh, this is nothing but layering because you are trying to convert untainted into tainted." I mean, that is the upshot, my lords, of the rest of the complaint. Then the definitions, etc., are expected. And the provisions of the Act. And then finally, conclusion at 109.
109.
Yes. Yes. It is clearly, as para 16, it is clearly established from the investigation and the evidences that the accused persons have committed the offense of money laundering as defined under section 3 read with 70 of PMLA, and they are liable to be prosecuted and punished under section 4, and the attached and seized properties involved in the money laundering are liable to be confiscated in terms of section 8(5) of the PMLA Act. And the prayer, my lords, take cognizance and pass appropriate orders, etc.
Yes.
Now, my lords, before I get into the, just have 2 or 3 provisions in the Act. Notes first, my lord, 21U.
Yes.
Proceeds of crime. Oh, this is better. This is better. Married, no?
Yes.
Proceeds of crime means any property derived or obtained directly or indirectly by any person as a result of criminal activity relating to a scheduled offense, or the value of any such property, or where such property is taken or held outside the country when the property equivalent is held within the country or abroad. Explanation: for the removal of doubts, it is hereby clarified that the proceeds of crime include property not only derived or obtained from the scheduled offense, but also any property which may directly or indirectly be derived or obtained as a result of any criminal activity relatable to the scheduled offense. Scheduled offense, my lords, is defined in 21Y. Scheduled offense means 1. The offense is specified under Part A of the schedule, or 2. The offense is specified under Part B of the schedule if the total value involved in such offenses is 1 crore or more. Earlier on, my lords, used to be 30 lakhs. And my lords, 3, the offense is specified under Part C of the schedule.
So in your case, it
Only Part A. Only Part A. But as I pointed out,
it is more than 1 crore?
No. Part A, there is no value. There is no threshold in Part A.
I got it.
Threshold is only for Part B. But your lordship's query is pertinent, my lord. Because originally, as I pointed out, PC Act was not in Part A. It was originally not there at all, if I'm not wrong. Then it was, it was originally only in Part B. Only in Part B. Then subsequently 13 is added and it is shifted to Part A only in 2013. Now, not section 3, the offense.
Is it 2013 or 2018?
18 is a further substitution.
Okay.
Because in 18, there is a further substitution where some more sections are added.
So 13 comes into picture in 2013.
13, that is my our reading. If I'm wrong, my friend, I'm sure will correct me.
Yes.
Now, section 3 is the offense of money laundering. Whoever directly or indirectly attempts to indulge or knowingly assists or knowingly is a party or is actually involved in any process or activity connected with the proceeds of crime, including its concealment, possession, acquisition or use, and projecting or claiming it as untainted, shall be guilty of the offense of money laundering. Now, Lord, the explanation was added, my lords, in 2019. For the removal of doubts, it is hereby clarified that 1. A person shall be guilty of offense of money laundering if such person is found to have directly or indirectly attempted to indulge or knowingly assisted or knowingly is a party or is actually involved in one or more of the following processes or activities connected with the proceeds of crime, namely concealment or possession or acquisition or use or projecting as untainted property or claiming as untainted property in any manner whatsoever. The process or activity connected with proceeds of crime is a continuing activity and continues till such time a person is directly or indirectly enjoying the proceeds of crime by its concealment or possession or acquisition or use of projecting it as untainted property or claiming it as untainted property in any manner whatsoever. It may be continuing, but that's from the when the offense starts. You cannot say, my lord, it is a continuing offense from 1990. It was not an offense in 1990. It was not an offense in 2000. It was not an offense up till 1st of July 2005. So at the very least, my lord, you have to first say when the offense commenced. You cannot say, my lord, with great respect, that it is deemed that all that period is the offense, irrespective. And therefore, in its sweep, I will bring, my lords, the entire 20 years and assume, my lords, ipso facto, it is proceeds of crime, because in the predicate offense, some number is given. The purpose of the investigation there is different. The purpose of the investigation there is not to find out what is the extent of money laundering. Because that is again in the context of, largely in the context of PC Act, because you're saying, what is the loss to the exchequer? It is not necessarily, not what happened with the, and also what period. Most important is what period. When does the money laundering start? You can't say I will go back in any point of time in the past and say I will pick up all your accounts and say no, everything is money laundering. Now in that context, if we can just see Vijay Madan Lal below. Which one is it in mind? Is it IWS?
Pass on a copy?
Yes, no, I'm giving a copy. Keep the full set, no. Keep to the other side. You have it?
You must be having it with those big clips also.
No, and for them it's the Bible, every case. But he has all of it. In this case, it's become the start and the end point.
With big clips, spiral binding and all that. Yes, which paragraph is
I will just give me 1 minute, Lord, in all this maze. No, I have to find which one I'm reading. Problem sometimes with too much technology, my lord. Anyway, give me the hard copy. I got it. First, para 65. Please give the corresponding page number from the calculation to the code.
65. Which begins with Mr. Siddharth Agarwal.
Yes. Learned senior counsel also appeared for the private parties. His main opposition is to the retrospective application of PMLA. Certain questions are raised with respect to whether prosecution for money laundering is permissible if the commission of scheduled offense and proceeds of crime takes place prior to the PMLA coming into force.
Yes.
And permissible if the commission of scheduled offences and proceeds of crime takes place prior to the PMLA coming into force. And similarly, in a situation when it is committed prior to the offence being made part of the schedule to the PMLA, both contentions are raised. It is submitted that the prohibition against retrospective operation of substantial criminal statutes is a constitutional imperative which needs to be given its fullest interpretation in a purposive manner. He highlights the three situations where interpretation is warranted. One, where transactions were concluded prior to the enforcement of PMLA. Two, prior to the offences being added to the schedule of PMLA. Three, whether amendment is applied with retrospective effect, couched in the guise of an explanation introduced by 2019 amendment. I am not so concerned with the third limb, my lord, but I would be covered both by the first and second limb of the argument. Because some part of my period is prior to 1/7/2005, and anyway the schedule added is 2009 and 2013. It is urged that no person can be convicted for criminal offense unless it has been specifically given retrospective effect, given the essential ingredient of knowledge of the person for taking such an action and exposing himself to criminal liability. In line with the protection under Article 20 and the maxim so and so, judgments of this court were relied to urge that the general rule is applicable when the purpose of the statute in question is to affect vested rights, impose new burdens, etc., etc. But I don't want to read the rest of the contention in great detail. And your lordship may come, Lord, straight away to para 270, my lord. Give the page number. 200? 270. It's 137 in the compilation.
Yes.
Here, my lords, to some extent, in fact, if I can read just above that from 269.
Yes.
From the bare language of Section 3 of the 2002 Act, it is amply clear that the offense of money laundering is an independent offense. Regarding the process or activity connected with the proceeds of crime, which had been derived or obtained as a result of criminal activity relating to or in relation to a scheduled offense, the process or activity can be in any form. It can be one of concealment, possession, acquisition, use of proceeds of crime, as much as projecting it as untainted or claiming it to be so. Thus, involvement in any one of such process or activity connected with the proceeds of crime would constitute offense of money laundering. The offense otherwise has nothing to do with the criminal activity related to a scheduled offense, except the proceeds of crime derived or obtained as a result of the crime. Needless to mention that such process or activity can be indulged in only after property is derived or obtained as a result of criminal activity, a scheduled offense. It would be an offense of money laundering to indulge in or to assist or being party to the process or activity connected with the proceeds of crime. And such process or activity in a given fact situation may be a continuing offense irrespective of the date and time of and commission of the scheduled offense. In other words, the criminal activity may have been committed before the same had been notified as scheduled offense for the purpose of 2002 Act. But if a person has indulged in or continues to indulge in directly or indirectly in dealing with proceeds of crime derived or obtained from such criminal activity, please note this, even after it has been notified as a scheduled offense, may be liable to be prosecuted for offense of money laundering under the 2002 Act. For continuing to possess or conceal the proceeds of crime fully or in part, or retaining possession thereof or uses it in, it should be tranches until fully exhausted. The offense of money laundering is not dependent on or linked to the date on which the scheduled offense, or if we may say so, the predicate offense has been committed. The relevant date, please note this, my lord, the relevant date is the date on which the person indulges in the process or activity connected with such proceeds of crime. These ingredients are intrinsic in the original provision. Section 3 as amended until 2013 and were enforced till 31/7/2019. And the same has merely been explained and clarified by explanation right so and so. Thus understood, the inclusion of clause 2 in explanation inserted in 2019 is of no consequence, as it does not alter or enlarge the scope of section 3 at all. Therefore, my lord, the court is clear, it pinpoints that what is relevant, my lord, is the date on which the activity of, my lord, money laundering or the proceeds of crime are actually utilized. Then, my lord, the lordship will come down a few more paragraphs. Kindly give the page number. 280, my lord. 280 and 281. I want to read those two paragraphs, my lord.
Yes.
We may also note that the argument that removing the necessity of projection from the definition will render the predicate offense and money laundering indistinguishable This, in our view, is ill-founded and fallacious. The plea cannot hold water for the simple reason that the scheduled offences in the 2002 Act, as it stands, amended up to date, are independent criminal acts. It is only when money is generated as a result of such acts that the 2002 Act steps in as soon as proceeds of crime are involved in any process or activity. Dealing with such proceeds of crime can be in any form, being process or activity. Thus, even assisting in the process or activity is a part of the crime of money laundering. We must keep in mind that for being liable to suffer legal consequences of one's action of indulging in the process of activity is sufficient, and not only upon projection of the ill-gotten money as untainted money. Many members of a crime syndicate could then simply keep the money with them for years to come. The hands of the law in such a situation cannot be bound and stopped from proceeding against such person if information of such illegitimate money is revealed even from unknown source. Next question is whether the offence under Section 3 is a standalone offence. Indeed, it is dependent on the wrongful and illegal gain of property as a result of criminal activity relating to a scheduled offence. Nevertheless, it is concerning the process or activity connected with such property which constitutes the offence of money laundering. The property must qualify the definition of proceeds of crime under 2(1)(u). As observed earlier, all or whole of the crime property linked to scheduled offence need not be regarding proceeds of crime. But all properties qualifying the definition of proceeds of crime under 2(1)(u) will necessarily be crime properties. Indeed, in the event of acquittal of the person concerned or being absolved from the allegation of criminal activity relating to scheduled offence, and if it is established in the court of law that crime property in the concerned case has been rightfully owned and possessed by him, such a property by no stretch of imagination can be termed as crime property and ex consequenti proceeds of crime within the meaning of 2(1)(u) as it stands today. On the other hand, in the trial in connection with the scheduled offence, the court would be obliged to direct return of such property as belonging to him. It would then be paradoxical to still regard such property as proceeds of crime, despite such adjudication by a court of competent jurisdiction. It is well within the jurisdiction of the concerned court trying the scheduled offence to pronounce on the matter. Therefore, what is clear from these three paragraphs, if I may say so, that no doubt it is an standalone offence. And since it is a standalone offence, my lord, there must be an identification, because it is not an ipso facto, my lords, that whatever is in the predicate offence becomes the proceeds of crime. And consequently, my lords, of course, if there is some success in the trial or a discharge or a quashing in the predicate offence, that benefit then automatically flow as far as the PMLA is concerned. Now, that, my lords, is my first submission as far as this aspect.
I think we'll have to stop today.
Very well.
1.5 hours already gone, so other matters are also there.
Certainly.
So when can you come again? Next week?
I have just, your lordship.
Next Friday? Yes, Mr. Agarwal?
Next Friday is
He's coming from outside, so that's why I'm
convenient.
Not Friday, no, only next Friday. I'm in some personal day.
Whenever you want. We'll keep it as part third.
25th. Can it be 29th or is that too late?
When is the second half? Build it, na? No, weekly. There's supplementary as well, but we bring it on. Is 26th a problem?
There is something listed in Supreme Court. I don't know. Unfortunately, in Supreme Court, we get now it's a date, it may change.
No, CG week Friday ta kete hoche?
29th Friday.
Saturday.
3rd May. 3rd May is a Friday.
Very well.
So the Friday, I'm taking bail matters in the weekly list.
Very well.
So by Friday, most of them are over.
Yes.
In fact, the list is over, but I'll be calling the passover matters.
Very good.
That's right. So that will be easier, isn't it? Because this matter has been specially assigned to me, assigned to this bench by Honorable the Chief Justice, as per His Lordship's endorsement on 18/3/2024. since the endorsement has been made as Honorable Sri Justice S.K. Mishra, the Deputy Registrar Judicial was called upon to confirm whether the matter has actually been assigned to this bench. Stop. The Deputy Registrar Judicial stated that the matter has actually been assigned to this court. As such, the matter was taken up for hearing. Heard in part. Place this matter on 3rd May, preferably at 2 p.m. At 2 p.m. At 2 p.m.
There's only one request more to my learned friend then, Milords. He was very kind, Milords, on 16th of February, as recorded in para 3 of the order, Milords, that in the meantime, they will not.
That will not, now I think summons has not been issued.
No, in fact, one was issued after this, your lordship's order. Of course, thereafter there has been none, but I just hope, Milords.
If he appears at files an application, the IA will consider.
That's exactly what my friend said, Milords, on para 3, Milords, that may be continued.
Para 3 of
order dated 16th of February 2024.
16th of February of this, in this case.
Yes, in this very matter, before your predecessor.
There is no order, may I place not that the petitioner may make an application before the investigation.
I'm comfortable with that.
On adjournment of the matter.
Similar arrangement as indicated in order dated 16. Similar arrangement as indicated in order dated 16/2/2024 at paragraph 3 shall continue.
I'm very grateful. I'm very sorry, Milords, for the longer accommodation.
No, absolutely not. It's a pleasure hearing you, Mr. Nair.
I'm very grateful.
Item 32.
Item 32 का मूव discuss CRLMC. Sir.
May I please, Lordship? In this case, my Lord. In this case, my Lord, the petitioners have prepared this petition before my Lordship for praying for quashing the criminal proceeding, my Lord. And this is the second journey of the petitioners, my Lord. And my Lord, in the meantime, the matter has already been settled. And the marriage, kindly have a glance at Annexure, my Lord. Annexure 6, my Lord. The marriage and between the petition number 6 and the my Lord, opposite party number 2 has already been solemnized. And
who's appealing for the other side?
Yes. And my Lord, they have been blessed with a male child, my Lord.
What is the offense?
376, my Lord.
CRLMC application.
I was not allowing 376.
The Lornet could be to conclude the trial within 3 months, my Lord. But the mother of the petition number 6, my Lord, is staying outside. She could not appear, my Lord, for which, my Lord, they could not appear, my Lord.
Mr. Bera, I never allow 376. I've never allowed a single application. That is why I probably you may have.
It's wrongly mentioned as SDJM Bhubaneswar instead of JMFC V Bhubaneswar. My Lord, may kindly modify this.
Mistake is yours or of the court?
It is mine.
All right, learn counsel for the petitioner. Is it a hatter All right, learn counsel for the petitioner is permitted to correct the name of the court in the cause title and other places of the anticipatory bail application. Whereupon necessary correction being made to the order dated 9/2/2024. Stop. Further, 2 weeks time is allowed to the petitioner to surrender in terms of such said order.
Blessed.
बंद करो weekly list.
Weekly list item number 2.
Non-appears license matter. Non-appears on repeated calls. License matter next week. We commencing 22nd April. Yes.
Item number 8.
Pass on behalf of senior advocate
Senior advocate,
Sir, Milan Kanu. Next week.
next week. This matter in the week commencing 15th April. As per for.
Item number 11.
Same order.
Item number 34.
Next week. Call it. Next week as per for.
Next week.
Next week as per for.
Okay.
Item number 35.
Passover matter, Mr. Daswal, dear Miller, he is on his legs in port number 5.
Next week.
Miller, he was here, Miller.
I've seen him. All right, I'm passing it over, but there no time nahi.
Next week, next week, actually.
What was it?
He was here.
No, he was here, senior counsel. Let us wait for some time. All right. Then
Item number 42.
42. Same next week. None appears next week. None appears.
Item number 48.
None appears next week.
Item number 50.
Lordship directed in compliance with Lordship direction, I filed affidavit. Copy was solved last occasion.
I think Mr. Kanangu was appearing in this case.
Mr. Ponda was
Mr. Devashish Ponda was appearing. So he is not there today. What can be done? As directed, land counsel to the informant files an affidavit in court. Have you served copy? After serving copy on the other side, indicating the details of the dues outstanding against the petitioner. Same be kept on record. Business matter next week.
Item number 56.
None appears next week.
Item number 67.
None appears next week.
Item number 68.
May I please, Lord, that matter, your Lordship was pleased to add this matter and directed to verify the statement of the injured. That the statement of the injured, which I have handed over the copy of the charge sheet and 161 statement. That's yes. 161 statement, it was provided by the petitioner's counsel. It was not in the record. But my lord, can you see the intention, my lord? 307 is there. And 27 arms act is there. Post occurrence witnesses, they have stated that the present petition was spread out. And the person who fired the injured, he has also come with the present petition in a bike. I'm reading some post occurrence witnesses statement, my lord.
FIR is unknown.
FIR, my lord.
FIR
unknown. FIR, my lord, unknown.
FIR is unknown. Yes.
That the post occurrence injured again, say discharge he gani. Mu again custodial rolani 6/8/2020 discharge, my lord. But mu phone taku motorcycle लेके छाड़ी जी मेडिकल रे.
Yes.
छाड़ी के पड़े वाली. और that post occurrence one विश्वरंजन बेउरे, my lord. जे मु छेली व्यापार करी मोर परिवार चलाए तेणु आम ग्रामर पड़िया जागा मानकर आनी मोर छेली मान चलाए आम ग्रामर बुटु महापात्र को भल भाव जाने घर नदी बंध कड़े अटे से जने कंट्राक्टर मु घर जागा जगी करी रहे से मते खर्च बार्च दियंती पाखक जगतसिंहपुर अंचल बहुत गुंडा श्रेणी पिला माने आसंती आम ग्रामर राजा सेनापति दैट माय प्रेजेंट पिटिशनर से मानन को नेकी आसे बुटु बाबू से माने मते पैसा पत्र दियंती गत 29/7/23 समय प्राय 4:30 समय मो आईतपुर ग्रामर आरंभ थिबा चौरा पाखरे बसिथिबा समय दुई जन पिला जे माने बुटु बाबू पाखु आगुरु जिबा आइसा करंती गोटे कला रंगर आपाची गाड़ी आसी नरेश साहू को कल घर भितर को पशिगले किछि समय पर आम गाँव राजा सेनापति चिकू भाईर बुलेट धरी आसी स्पीड रे कल घर भितर पशिगले तापर गुड़ी फुटबार शब्द सुबिला आम गाँव किछि लोक जो माने सेठी थिलु दौड़ा दौड़ी सेटाई गलु और सेटारे देखिलु जे से पिलार पेटरे गुड़ी बाची से सेटारे छटपट होउची राजा सेनापति प्रेजेंट पिटिशन राजा सेनापति आर पिलाटी
ତା ହାତରେ ବନ୍ଧୁକ ଧରି ମାରିଲା ପରି ଛିଡା ହୋଇଛନ୍ତି। ଲୋକମାନଙ୍କୁ ଦେଖି ଆର ପିଲାଟି କଳା ଆପାଚି ଗାଡିରେ ପଳେଇଲା ଓ ରାଜା ସେନାପତି ସେଇ ବୁଲେଟ ଗାଡି ଧରି ସେଠାରୁ ପଳେଇଲା। ଗୁଳି ଖାଇଥିବା ପିଲାଟି ତାକୁ ଭଙ୍ଗା ରାଜା ଗୁଳି ମାରିଛି କହି ବଞ୍ଚାଇ ଦେବାକୁ ଅନୁରୋଧ କରିଥିଲା, କିନ୍ତୁ ଗାଁ ଲୋକମାନେ ଭୟରେ ଦୌଡ଼ି ପଳେଇବାରୁ ମୁଁ ମଧ୍ୟ ସେଠାରୁ ପଳେଇ ଆସିଲି। ଭଙ୍ଗା ରାଜା ପିଲାଟି ଓ ଗୁଳି ଖାଇଥିବା ପିଲାଟି ବୁଟୁ ବାବୁଙ୍କ ପାଖକୁ ଆସନ୍ତି। ଭଙ୍ଗା ରାଜାର ନାମ ରାଜା ବେହେରା। So the present petitioner was fled away, my lord, from the spot. Another post-occurring witnesses, he has also stated, my lord, same thing. Only in the 161 statement of the injured which was provided by the present petitioner, he stated that that the injured was taken by the present petitioner to the hospital. And as well as, my lord, there is 80 numbers of antecedent of the present petitioner of the, my lord, similar nature, 25, 27 are accepted. And another person, my lord, that Norris Sahu. ଯେ ମୋର ନାମ ମୁଁ ପରମପୁର ଗ୍ରାମର ବୁଟ ମହାପାତ୍ର ଭଲ ଭାବେ ଜଣେ, ସେ ଜଣେ କଣ୍ଟ୍ରାକ୍ଟର। ତାଙ୍କ ପାଖକୁ ଜଗତସିଂହପୁର ଅଞ୍ଚଳ ବହୁତ ଗୁଣ୍ଡା ଶ୍ରେଣୀର ପିଲାମାନେ ଆସନ୍ତି। ଆଚ୍ଛା, ମୁଁ ସେମାନଙ୍କୁ ଅନେକ ଥର ମନା, ହଁ, ସେମାନେ ମୋର ଥିବା ଏକ ବନ୍ଦ କଳ ଘର ଭିତରେ ସେମାନେ ବସା ଉଠା କରନ୍ତି, ଯୋଉ ଜାଗାରେ ଫାୟାର ହେଇଥିଲା। ସ୍ପଟ ବକରେଞ୍ଜ, ହି ଇଜ ଦ ଓନର ଅଫ ଦ୍ୟାଟ କଳ ଘର ଭିତରେ। ମୁଁ ସେମାନଙ୍କୁ ଅନେକ ଥର ମନା କରିଛି, କିନ୍ତୁ ସେମାନେ ଶୁଣନ୍ତି ନାହିଁ। ଗତ 29/7/23 ସମୟ ପ୍ରାୟ 4ଟା ସମୟରେ ମୁଁ ଆମ ବନ୍ଦ କଳ ଘର ପାଖରୁ ଏକ ଗୁଳି ଶବ୍ଦ ଶୁଣି ମୁଁ ସେଠାକୁ ଦୌଡ଼ି ଯାଇ ଦେଖେ ତ 2 ଜଣ ପିଲା ଯେଉଁମାନେ ବୁଟୁ ବାବୁଙ୍କ ପାଖରୁ ଆଗରୁ ଯିବା ଆସିବା କରନ୍ତି, ସେମାନଙ୍କ ମଧ୍ୟରୁ ଜଣେ ପିଲାର ପେଟରେ ଗୁଳି ବାଜିଛି ଓ ସେଠାରେ ଛଟପଟ ହେଉଛି। ରାଜା ସେନାପତି ପ୍ରେଜେଣ୍ଟ ପିଟିସନ ଏକ ବୁଲେଟ ମୋଟର ସାଇକେଲ ଏବଂ ଆର ପିଲାଟି ଗୋଟେ ଆପାଚି ମୋଟର ସାଇକେଲରେ ସେଠାରୁ ପଳାଇ ଯାଇଥିଲେ। ଗୁଳି ଖାଇଥିବା ପିଲାଟି ତାକୁ ଭଙ୍ଗା ରାଜା ଗୁଳି ମାରିଛି ବୋଲି କହି ବଞ୍ଚାଇ ଦେବାକୁ ଅନୁରୋଧ କରିଥିଲା, କିନ୍ତୁ ଗାଁ ଲୋକମାନେ ଭୟରେ ଦୌଡ଼ି ପଳାଇବାରୁ ମୁଁ ମଧ୍ୟ ପଳାଇ ଆସିଲି। ଭଙ୍ଗା ରାଜା ପିଲାଟି ଓ ଗୁଳି ଖାଇଥିବା ପିଲାଟି ବୁଟୁ ବାବୁଙ୍କ ପାଖକୁ ଆସନ୍ତି। ଭଙ୍ଗା ରାଜାର ନାମ ରାଜା ବେହେରା।
No, but this is contradicting the 161 of the injured.
My lord, only that I am all
Open the case.
yes, my lord, that is that I want.
Let us find out. There seems to be an apparent contradiction. Let him find out. Let us be satisfied that because the injured is the best witness. Best witness. If he says that this person took him to the hospital, then obviously the intention part will be a little bit doubtful. Let us see. Let us see.
এটা মূলত ক্রিস্টাল ক্লিয়ার দ্যাট দ্য পারসন হু ফায়ার্ড হিজ নেম ইজ রাজা বেহেরা। রাজা বেহেরা ମୁଁ ହଉଛି ରାଜା ଆଲିଏସ୍ ବିବେକାନନ୍ଦ ସେନାପତି। ମୁଁ ଆଜ୍ଞା ମାରିନି। Even if my lord accepting the prosecution allegation is to be true for the sake of argument, and my lord period of detention, my lord near about that I mean custody since 6/8/2023.
Hell, I think it's 161 asu.
And then condition will can
No, let the 161 come.
No perfect.
The case diary available with the state council does not contain the 161 statement of the injured.
Injured Shakti Charana Mohanty.
Shakti Charan Mahathir. Which is required to be
Shakti Chandan.
Shakti Chandan Mahathir, which is required to be produced. Let's this matter next week, you know? Let's this matter in the week commencing 15th.
15th 18th 19th ଯଦି ଆସିଯିବ ଆଗରେ ଆଉ ଆସିପାରିବ 22nd
ଆଚ୍ଛା 22nd April. ଭଲ। 22nd April କଣ?
ହେଇଗଲାଣି ବହୁତ ଦିନ ହେଇଗଲାଣି।
କଣ ବହୁତ ଦିନ ଆଉ ଗୋଟେ week ହେଇଗଲା କଣ? Yes.
Item number 71.
71. Same, none appears next week.
Item number 82.
82. None appears next week.
Item number 84.
Same.
Item number 90.
90, yes.
My lord, the alleged offence under section 302, the FIR is unknown. The wife of the deceased lodged the FIR. That is at page 7, you will also kindly see it.
The 90 my lord CD required 302 matter.
Well, the field case that you open, let's just matter in the week commencing 3rd May. Yes. Hola.
So we commencing 29th April.
29th April. Okay.
Item 97.
I am at VC, my lord. Petition
Yes.
in custody since 15/9/2023. Charge sheet submitted 26/2/2024, my lord. Allegation ହେଲା ଯେ ଗୋଟେ ଅଙ୍ଗନବାଡି ସରକାରୀ ଅଙ୍ଗନବାଡି କେନ୍ଦ୍ରର 3ଟା ଜରି 25 କେଜି ଲେଖାଏଁ ଥିଲା, ସେଇଟା ପିଟିସନର ପଜେସନରେ ଥିଲା ବୋଲି କହୁଛନ୍ତି।
Yes, they required, my lord. 75 kg. This matter missing. Case data ଆସିବନି?
ଆଜ୍ଞା ଏଟା ଡିସେମ୍ବର ହେଲାଣି ଲାଷ୍ଟ ଅକେଜନ ବି ସେ ଆଣୁନାହାନ୍ତି
ହଁ ହେଲା ଆସିବ ବ୍ୟସ୍ତ କାହିଁ ଅଛ?
ଲାଷ୍ଟ ଅକେଜନ ବି ସେ କରିଦେଲେ ନେକ୍ସଟ ୱିକ୍ ଆସିବ ମୁଁ ଟିକେ ଚେଷ୍ଟା କରି ପଠେଇଦେବି
No. This is matter in the week commencing 22nd April. The case diary will be produced positively. Yes. Item number 100. How would a matter flag? You had another matter?
Yes, yes, sir. Okay.
This is also your matter?
Yes, yes.
100.
Okay. Very interesting case, my lord.
This was not heard earlier?
No, it was heard by my lord Justice Gauri and then my lord the changed. It heard that matter.
Okay.
So my lord, point at issue is, here is a man who goes, all of them go to a person called Hanuman Baba. They sit there and they give money to this man to give a public employment. That I am very close to Dharmendra Pradhan, close to ABZ, and I'll get you a job. On the basis of that, they pay money. And that is the money that is the FIR.
So he has taken how much?
From 25 lakhs they paid. 58 lakhs of 59 lakhs something. And that he is not taken. The Baba is the prime mover, my lord.
Now, who are you?
I am supposed to be a person who is also a Bhakt of the Baba.
No, Baba has been suicided as well.
So what, according to the prosecution, is your role?
My role is that, my lord, I promised them job in a government job.
Government. Who took the money?
And I am supposed to have taken them.
Okay. Then you will have to pay something?
No, clearly, my lord, section 23, but clearly, my lord, how can they, this is void contract, my lord. And this is, how can they, obviously they are lying. Because, my lord, how
in all such cases, we are not actually looking at the voidability of the contract. It is true. 23 comes into the picture. But to strike a balance, normally we ask the.
No, my lord, I am not in that, my lord. What has happened, my lord, with all, in the reality again, is that the money goes away more to the Baba than the others. And this poor man is in jail custody for last almost now 9.
I will not call him a poor man, but you may, but I will not call him a poor man or treat him like that.
No, my lord. Totally uneducated. Not even matriculate. They believe that man and then they give 25 lakhs. My lord, who is ever going to believe this, my lord? And since they cannot recover it, they said the criminal.
But what is the evidence?
Evidence is there, account transaction is there, my lord.
Account transaction amounting to
one victim, Narendra Singh, 1,50,000.
No, what about the total amount?
59 lakhs 25,100.
You have paid.
Seven
the informant.
I am for the informant.
Yes.
One Pankaj Moto, 2,99,000.
7 number of persons.
One Chandra Mudali,
25,100.
So how much have you paid?
I have paid 20 lakhs. 20 lakhs is 60,000.
20 lakhs.
From different victims.
Other FIRs, how many persons have lodged FIR? 1, 2, 3, 4, 5, 6 jana. 6, 7 jana. 7 informants are here.
Yes, yes.
So total amount is 58 lakhs.
Yes.
59 lakhs 25,100.
Yes.
All the transactions.
And what is the reason, my lord, let the FIR be right, my lord, can we read the FIR? They say that he will give public employment. Sarkari chakir debo, Indian Oil chakir debo. Indian Railway. And this is the reason they pay. Aren't they as much, my lord, culprits as this man is? Don't they know how how an employment is given?
No, that's already pay some amount. Some amount. Token amount. You have taken 58 lakhs.
Yes. That is their allegation, my lord.
No, there is a proof. It is a bank transaction.
It can be business transaction also, my lord.
Then you have to show what is the business. What is the source of that money?
Money, my lord, I can show that also, my lord.
You show that. You show that. If you can convince the court that that amount was transmitted to your account from a legitimate source, the court will be willing to accept it.
My lord, kindly ask them whether they have paid this money for this, if they have paid this money for this, and they shouldn't be in the proceeding also be against them, my lord.
No, it's open to you to still again initiate a proceeding and also open to the prosecution to initiate a proceeding.
They should be, do that, my lord.
No, that is there. And in any case, this is a voidable, it's a void contract.
Yes.
It's a void contract, I do.
It's not voidable also.
It's not voidable, it's a void contract.
Yes.
And I can also put the question to him that if he wants recovery of his money, he can go to the civil court also.
And he cannot file recover.
Because it's a void contract.
It's a void, because it's a void contract when section 23
Then nevertheless, this being a court of equity, we look at the larger picture, we say so some amount may be paid so that your bona fides are.
Yeah, but my lord, I have so much of respect for this honorable court, my lord. I don't even want to cite judgments on the line of which are otherwise, my lord. My lord, I don't know, my lord, it's so very embarrassing for me.
No, that's almost all this kind of cases.
No, I bow down to that, my lord. My lord, I have given my lord a judgment last time, my lord. And 6 other judgments are there, my lord, that court should not become a agent for recovery of people's money.
No, we want to see the bona fides of the person. That's all. It's not a question of we are not recovering. Because whenever we pass such an order, we always invariably, no, Mr. Das, in every case we say that it will be without prejudice.
Yes. But that judgment I have given, my lord, Justice Datta and Ravindra categorically saying that also shouldn't be done. That also shouldn't be done. My lord, I'll cite that judgment, my lord. I leave it to your lordship. Because if your lordship decides to put a caveat on the release, my lord, I have to accept it. There's no issue on that. But why don't you kindly see the line of judgments, my lord? That one is that Justice Indira Banerjee. One is the latest judgment I've given to my lords. Yes. I've given the list of citations also, my lord.
In other case.
My lord, in the other case, I'm giving all the citations, my lord, for the purpose of this, my lord. And my lord, I've also given the judgments of the Supreme Court where that judgment is at
Page 78.
page 78.
78 to 90.
I bow down to what is falling from my lord. I'm not on that. Yes. My lord, this applies to 438 and 439 both. My lord, may kindly see paragraph 26, page 90.
Page 90?
Yes. That means 90, my lord, in my paper book.
Yes.
Law regarding exercise of discretion in granting bail in under 438 CRPC having authoritatively determined by this court, we cannot but disapprove of imposition of a condition in the nature on the challenge. Assuming that there is a substance in the allegation that a complaint of the appellant, either in connivance with the builder or even in the absence of such connivance, has cheated the complainants, the investigation is yet to result in a charge sheet filed under 172(2), and not to speak of the alleged offence being proved before the competent court in accordance with settled provisions of applicable law. Say subsection 2 of subsection 438 does not empower the High Court or the Court of Sessions to impose conditions while making directions under subsection 1 as it may think fit in the light of the facts of a particular case, and such direction may include conditions such as clauses 1 to 4. However, in a reading of the precedents laid down by this court referred to above, the provision of law is clear that conditions must not be onerous or unreasonable or excessive. In this context, grant of bail, all conditions which would facilitate the appearance of the petitioner before the investigating authority unhindered by completion of investigation and trial, the safety of the community assume significance. However, inclusion of a condition of payment of money by the applicant for bail tends to create an impression that a bail could be secured by depositing money alleged to have been cheated. This is really not the purpose and intent of the provisions of the grant of bail. We, however, are not understood to have laid down the law. In no case the willingness to pay the deposit of the can be considered to a grant of bail in exceptional cases where the allegation of misappropriation of public money. But if it's public money, like my lord in that place, my lord, supposing my lord a sarpanch, that my lord scan. That is the only exception, my lord. Because my lord, there public money is there. Here, my lord, it's a contract, and that was a contract which was hit by 23.
Between the private person.
And between two private people, my lord. And that was not a written contract by word of the mouth.
For what they have paid the money, my lord, they cannot themselves say, except for that bond statement in the FIR. Just a minute. Misappropriation of public money of accused is leveled against an accused while seeking indulgence of the court to have liberty secured, restored, volunteers to account for the whole or any part of the public money alleged to have been misappropriated. It will be open to the concerned court to consider whether larger public interest money misappropriated should be allowed to be deposited before the application of the anticipatory bail is taken, or anticipatory bail / bail, my lord, taken for the fine concern. After all, no court should averse to be putting public money back into a system if the situation is conducive. Therefore, we are minded to think that this approach would be in larger interest to the community. However, such an approach would not be warranted in case of private disputes where private parties complain that their money has been involved in the offense of cheating. Then, my lord, the other judgments also decide. And the next page, turning to the facts, when the facts are he accepted and said he agreed to pay 20 lakhs. He didn't pay and the bail was not granted. He came in with that. And interim protection was given, direction was given that you consider the bail application. Here, but then thereafter, high courts ought to realize that with regard to the nature of a dispute of parties, which is predominantly civil in nature. But this is predominantly civil in nature. Next page. The criminal court cannot be pressed in service to setting civil disputes. Even if such an appellant is undertaken to make payment, which we are inclined to believe was last-ditch effort. This matter money had been paid. He agreed to pay. Still, my lord, the court said, Honorable Supreme Court said that to avert to losing liberty, such an undertaking would be weighed in the mind of the High Court to decide the question for grant of anticipatory bail. It is also doesn't appear in the material that the complaints have instituted any civil suit. Next paragraph, paragraph 28 of the civil suit. In regard to and here where they cannot. Even 63 will not protect them. 63 or 64 also not will protect them. If it was a voidable contract, then my lord, they could have gone there, my lord. Or it became impossible. Then they would have gone to 63. Here it's a void contract, my lord. And specifically public service has been indicated in 623. If all the offences alleged in it are proved resulting in conviction, he would be bound to suffer penal consequences. But despite such a conviction, he may not be under any obligation to repay the amount alleged. That too, in this aspect of the High Court exercising jurisdiction, the 438 did not bear in mind. My lord, next paragraph 32, my lord, mechanically. I was stating this, my lord. Before concluding, we need to dispose of IAS of also the intervention at the instance of complainant who seek assist the court on the ground that the order passed in appeal without giving an opportunity of hearing to them will prejudice. We hold at this stage the complainants did not have a right of audience before this court, before the 438 court, my lord. Even the High Court having regard to the nature of the offence, it is alleged to be committed to happen, unless, of course, it is a situation for compounding of the offence. Suppose I agree to compound it, my lord. Then, my lord, can exercise for it. I will surrender to 482 and say that my lord may quash the matter with by having paid money. That also is not there. And prior to that, my lord, Sibba and all others have been cited.
That may be necessary.
Yes. So that's the law.
Yes. What do you say? Well, all the transaction has been done in account manner. So there is no way that they have not paid the money. What is the motive? That is not there. But they have paid and the present petitioner has received the money.
What about what is your response to the decision that has been cited just now by the senior counsel on the point of law?
It's a contract. Contract not it's a written contract, my lord.
ସେ ନିଜେ କହୁଛନ୍ତି ନା ଏଇଠି କହିଲେ ମୁଁ ପ୍ରତିଦିନ ତୁଷାର ଗଲା ଯିବା ଆସିବା କରେ ଏଠାରେ ଥିବା ହଠାତ୍ ହନୁମାନ ପ୍ରରଞ୍ଜନ ଅପରିଚିତ ବ୍ୟକ୍ତି ଶ୍ରୀ ସନ୍ତୋଷ ମହାନ୍ତିଙ୍କର ନିଜକୁ ବ୍ୟକ୍ତିଗତ ସଚିବ କହି ନିଜର ପରିଚୟ ଦେଇଥିଲେ। ଏଥିସହିତ ପୂର୍ବତନ ମନ୍ତ୍ରୀ ରଘୁନାଥ ମହାନ୍ତିଙ୍କର ପୁତୁରା କହି ହନୁମାନ there may be some other thing because nobody would, if somebody is unemployed, how will you have 58 lakhs with him to pay? If he has 58 lakhs With that kind of money he has, he could have started as well a business.
Not
Right.
one person, my lord.
7%.
6 to 7% are there, my lord.
ତିନୋଟି ସ୍ଥାୟୀ ଚାକିରି ଏବଂ ଆରୋଗ୍ୟ ବିଶୋଧନାଗାରରେ 4ଟି ସ୍ଥାୟୀ ଚାକିରି।
My lord is aware, Haryana, the chief minister had to go because of this. Forget about others, my lord.
And this also, I mean, by admitting that I had paid money for a wrong cause, because you are trying to secure employment by unfair means, by bribing somebody.
Yes. By identifying themselves as a high profile person. So
they are guilty of impersonation, cheating, everything. That's all right. We're not denying it. So, yes.
But anyway, they have taken money.
The fact is, kindly see the cost title. The person not seems to be proved to be fraud because of the name Santosh Mohanty, alias Santosh Mahuri, alias Haribandhu. The name itself proves that that person is a fraud. Thereafter,
the name proves that it is a fraud.
Tinta na jane kahi karibo. To prove that, some documents have seized by the police. Prove that. No, I am not saying. দুইটা সে প্যান কার্ড করেছি, দুইটা নম্বর, সন্তোষ মহান্তি, ইন্ডিয়ান এয়ারফোর্স রে।
That is only merit. You answer to one senior counsel has said.
Number two, my learned seniors, as far as submission my learned senior I have had fully, I want to say that in totally taking consideration of the my learned seniors, I presumed that FIR could not stand. That required was on the version of my learned senior.
It is still open to him. He may.
As I think, it is my presumption, entire submission goes to one round that the FIR could not stand. There won't be no case. Here is the point. I want to say something. In taking 7 days time, I will submit some judgment. I will submit very fact, but my humble submission, petitioner may be directed to give me a copy with annexures. I have no copy with annexures. Some documents are here. Okay? Within 7 days time, I will submit the judgments.
But you give him a copy.
I will convince the
give him a copy
as per my capability.
Give him the copy to him. If you want to
request transfer me. Earlier it was the earlier council has served the copy.
So ଆପଣ ଆଉ ଗୋଟେ ଦେଇ ଦିଅନ୍ତୁ।
No. ମୋତେ କିଛି copy serve ହେଇ ନାହିଁ।
Let us. You give another copy. Let us forget about whether copy was given or not. Give another copy. End of the matter. We'll take it up next week. Let a copy of the brief.
Exact submission was made on the last. Let him convince.
No, it is not a fact. It is a new fact I had. On the basis of a judgment, one rights cannot be taken away. Whatever be the judgment, no judgment can taken away any rights.
It was meant for my lord.
Yes, we are keeping it.
Yes.
My submission is, one judgment cannot taken away any rights of a citizen of India. Here is section 420.
He has either a choice to get a copy from me or argue. He can't have that.
You take a copy.
Okay.
You make your submissions next week.
Miller.
Let an extra copy of the anticipatory bail application be served upon Learned Counsel appearing for the informant. Let this matter. We'll take it up next week. Mr. Das, next week.
Whichever date, if I'm not able to come, my lord,
yes, you have made your substantially, you have made your. We'll make it in the week commencing 22nd. 22nd April. The week commencing. It will come in the weekly list. It will be there for the entire week.
All right, my lord, 22nd is all right.
22nd, no, it is 22nd, the week commencing 22nd. So the entire week it will be there.
If my only request is, my lord, I may request for 1 day later or 1 day earlier. That is all.
Yes. That will be done.
Item 35.
May I be pardoned?
35.
Yes.
May I be pardoned?
Yes.
When item 50 was there, I couldn't be when the matter was called. Can it be taken up on Monday?
We'll take it. It will come in the item 35 page. Next page. It will come in the weekly list in the next week.
My lords, weekly list. Monday, I am saying why? Because otherwise I'll again be in a precarious position.
No, Monday probably it will reach on Monday. It will, since this week it was 35. If it doesn't reach, if it is listed a little later, I mean downwards, then you can make a mention.
Yes, it was item 15 today, this month.
Today weekly list. It was item 15 weekly list.
I think 15 weekly list. So प्रथम दिन तो पड़ी थी लाउड. The first day itself it was yes, or second day. So you can make a mention. We'll take it up. Yes. Now item
35. But I was already submitted. This one, no? I've submitted. My lord wanted to ask me that very question, my lord, that how much of money are you prepared to pay? Yes, that to you matter, my lord. There is a difficulty, my lord. Difficulty is this, my lord. Surface has been initiated. All my bank accounts are seized. I am both of them are there. I have to have a holistic. I cannot. If I give money with them, my lord, I will be held in contempt with Surface because Surface they are number one now. So you can't pay them. It will be. I cannot even pay, my lord. I am physically not having money now, my lord. Physically, there is no money because all the accounts have been seized, my lord. Once I come out, my lord, I will probably. I also want to settle the matter, my lord. And I will probably sell some property and try to settle all the matter.
I'll grant you 3 months time.
Yes, yes.
I'll grant you 3 months time interim bill so that he can. I'll keep the matter pending. I'll keep the matter pending. I'll release you on interim bill subject to the condition that you will make sincere efforts to sell off your properties to settle the matter.
Yes, my lord. Well, at least, yes, my lord, give me.
I think that is a fair order. Yes.
To the informants only, informant.
Informant, yes, obviously it is the informant.
Informant only, because otherwise, my lord, will be the exodus of people, my lord. I would like to settle, my lord, when 29 places have finished, my lord. I'm a chartered accountant by occupation, my lord. I came into this business. I have 29 others which have done very well.
This is that flat thing.
Yes, my lord. 31 I have finished. And so I am in a monumental mess, my lord. Not as if it was any intentional thing. My lord, COVID came in. And all these things obviously cramped my effort.
Yes, Mr. Patra, what do you say?
That is there, but during his,
I've given
one submission, my lord. During his interim bill, my lord, he may be directed to submit his passport.
Can be done.
Yes, my submission is that he has allotted 49 plots instead of 42. The intention like this.
Yes,
it's a CORAM. You are viewing the informant. You should be interested in getting back your amount. So if he makes a submission,
the subject on a condition that subject to passport and other things, but
that will be there.
He will take effective steps to realize refund the amount of the
otherwise the interim bill will not be extended.
Yes.
So that will be the condition.
Because I've given in that compilation, my lord, I've given all the judgments, including judgments regarding OPID and Winger, where my lord stay has been granted without any effort by the Supreme Court. I've given all those judgments.
But in OPID matters,
OPID.
Even in OPID matters, I will.
Yes, no.
And asking you to pay a particular amount, but I considering your submission that the matter can also be settled. With that, you may make sincere efforts to pay off some dues to the informant. This court can release you on interim bail.
Yes.
Grant you 3 months time to do that and to prove your bona fides. Come back to the court and say that this is the amount I've already paid, which proves my bona fides. The Supreme Court is also passing such orders in many cases.
Yes, provided, my lord, in those cases, my lord, what is happening, if it is pertaining to public money, yes, all. My lord, I have given the compilation judgments. I have done from Orissa 7 matters, my lord, where the builders have been let out without any payment.
No, I am not asking you to pay anything. I will ask you to sincerely take 3 months time to settle the amount.
All efforts, my lord, may give 4 months, it will be easier.
4 months.
Complete project after releasing the.
I will try to.
3 months is reasonable.
He's in custody for 1.5 years. Let him come out, my lord. I'll get him to try to, because everyone's property, including my sister's property, everyone's property is involved.
So, 3 months is a fair time, a reasonable time. Let him come back, and within 3 months, if he can convince the court that he has been making sincere efforts, then it can be extended.
Yes. No, my lord. What is happening, my lord? I would like to, because that will not give a quietus to the entire proceeding, my lord.
No, it won't.
Yes. So that,
and we're on bail. Why should this court now think about having a quietus over the entire issue? That will take its own toll.
Of course.
So, anyway, I'll pass orders.
Yes, sir. And only one thing, only one line, our objection were recorded.
Obviously, your objection will be recorded, Mr. Patra. You cannot concede.
Not considered. You have objected. You have objected. Your objection will be recorded, including that of Mr. Miller. Do it. Yes. You want to file any note here in this case?
Already filed.
You have already filed a note. All right, I'll ask.
And I've given all the judgments, my lord, all the judgments regarding payment, all the judgments, including Justice Indira Banerjee's every other judgment, which have been referred to all of this in that judgment.
My sense is that you are directed to produce the list of all tickets. Because actually there are 32 flats, but there are like 49. Who are they? But we have given.
Are you wanting to convert this into a civil proceeding? My lord?
That's intent.
That's all. Yes, Mr. Mishra?
No, I mean sub item.
Oh, yeah. There are the second item, same director.
Same
Maybe,
person.
There are same room.
One MD and two director.
Informant is the same.
Yes, yes.
Okay.